wish to insert the word dominant before the word purpose?
Yes, it's line 1, 2, 3, 4, 5, 6, 7. It to insert
7.
Dominant on the.
So can you read the whole sentence that you wish to change?
The same applies to communications between a lawyer and their client, or a third party for the insert dominant.
Oh, okay. It's that
purpose.
Is that purpose, not the earlier one that I identified?
Thank you.
So insert the word dominant before purpose.
Thank you.
With those 4 corrections in mind, there are some minor typographical errors that I'm not going to go through and correct. There's quite a few of those, but I'm not going to correct them. With those 4 substantive corrections in mind, are the contents of the witness statement true to the best of your knowledge and belief?
They are.
Thank you very much. That witness statement can come down. As I've said, the witness statement is very detailed, and you've obviously devoted a substantial period of time to the making of it by setting out the relevant events in largely chronological order and adding your recollections where you have them. I'm accordingly not going to ask you detailed questions about every aspect of the witness statement, but instead take you to some of the more significant events over the past 12, 13 years or so. Can I start with your background, please? You joined the Post Office in August 2012, is that right?
Yes, it's late August.
And you remain an employee of the Post Office?
Yes.
And specifically, you are the head of legal in the Post Office's remediation unit?
I'm a head of legal in the remediation unit, yes.
Oh, there's more than one head of legal? Okay.
Yes.
How many heads of legal are there in the remediation unit?
At the moment, I think there may be another 2 or possibly 3. I'm not sure, I'm sorry.
Okay, so you're one of the heads of legal within the remediation unit, is that right?
Correct.
And I think you've held that role in the remediation unit since August 2020.
Yes.
The Post Office's website suggests that the remediation unit has 3 main functions: compensation and redress for sub-postmasters, administering matters related to the appeals of historic criminal convictions, and the provision of full assistance to this inquiry. Is that a fair summary of what it does?
I had thought the inquiry was separate, but it seems correct, yes.
If you felt that it was separate, I mean, you work in it, is it separate or not?
I don't deal with the inquiry team, so I thought it was separate.
Right. So do you deal with compensation and redress?
I have done previously, yes.
And do you deal with matters relating to the appeals of historic convictions?
I have assisted the company with that, yes.
I'm sorry, I missed you there.
I'm sorry, I have assisted the company with that, yes.
Does it follow that, notwithstanding your personal role in the events which have happened since August 2012, you hold a senior position in the unit concerned with the provision of redress to sub-postmasters?
Yes.
And with the administration of issues relating to the appeals against their convictions?
Yes.
In terms of your qualifications, I think you were admitted as a solicitor and a barrister in New Zealand in 1995.
Correct.
And you worked in that country on civil matters until 1998.
Yes.
And from 1999, you worked in civil litigation practice in the United Kingdom, and you were then admitted as a solicitor of England and Wales in 2002, is that right?
Yes.
You worked in New York between 2003 and 6, when you then returned to the UK again to work in civil litigation matters.
Yes, I came back from New York at the end of 2005.
Overall, do you accept, therefore, that you had considerable and wide-ranging experience as a civil litigator in private practice prior to joining the Post Office?
Yes.
Do you accept that since joining the Post Office, you remained bound at all times by the SRA's Code of Conduct?
I do.
If we turn up, please, on the screen, page 11 of your witness statement and paragraph 22. page 11, paragraph 22. You say in the first sentence you'd often been asked to distill or synthesize information provided from various parts of the business for other audiences within the business, particularly if the information concerns legal issues with which I have some familiarity. And then at the end of the paragraph, you say, I generally rely on others for the accuracy of the content, especially if it concerns areas outside my expertise, with my role being to, quote, sense check it. Yes?
Yes.
That might be interpreted as meaning that your role was limited to one of gathering pieces of paper written by other people together, like a cataloguer of information. Is that what you were trying to say?
Yes.
It might be interpreted as meaning that your role was limited to summarising the legal advice of others. Is that what you were trying to say?
No, not necessarily. It would depend on the task at hand.
And so over the decade period that we're talking about, sometimes you provided legal advice of your own?
Yeah, I would think that was right, yes.
You didn't simply distill or synthesize the legal advice of others?
Not exclusively, but I would have said predominantly with the matters we're concerned with here.
You mainly summarize other people's legal advice in that 10-year period, is that right?
No, I think that's an oversimplification.
You tell us then.
I'm sorry, what would you...
Yes,
I'm struggling to understand, I'm sorry.
Yes, it's entirely my fault. What was your role, looking at it as a whole, in the provision of legal advice to the Post Office concerning the Horizon system and matters that concerned it? Did you mainly summarise other people's legal advice and sense check it?
No,
or did you provide legal advice of your own?
It would literally depend. It's a very broad subject over a long period of time. My primary role was to ensure that the company was receiving the advice it needed. That might have come from a variety of sources. It may have been something I could contribute to. But the concern was the delivery to Post Office so that it could act as it saw fit or as it saw it needed to.
So it's neither one thing nor the other, it's both, depending on the context.
Quite possibly, and possibly at the same time. It may be that I could contribute in addition to formal advice received, but
in terms of the period before you moved to the remediation unit, so from the time when you joined the Post Office in August 2012 until I think August 2020, that 10-year period, what was your job title?
I think it changed halfway through. I was hired as, quote, litigation lawyer, I think was the title. And then I became head of legal, brackets, dispute resolution and brand.
And when was that, please?
I think that was in 2017. It's in my statement.
So, sorry, that can come down the statement that's on the screen, thank you. Before you became head of legal in 2017, to whom did you report?
I reported initially, before I became head of legal, yes, I reported to a head of legal.
And who was that?
For a period, I'm sorry, I can't remember the dates. It was to Hugh Flemington for a period, and then a colleague called Jessica Madron.
And after you became head of legal, to whom did you report?
I reported to the legal director, who was Ben Fote.
And has that been for the entirety of the period from 17 until today?
No, not until today, no. It was until I moved to the remediation unit.
Okay. Between August 2012 and moving to the remediation unit, did you become aware of the very high number of prosecutions that had been, and when you joined were still being brought against sub-postmasters by the Post Office?
I'm sorry, what was the date range again, please?
August 2012.
Until
you moved to the remediation unit.
I became aware, yes.
When did you become aware of the numbers of prosecutions?
I couldn't tell you.
When you joined, were you aware that the Post Office was a prosecuting authority?
I don't know that. I became aware shortly after I joined that there was prosecution activity, yes. I don't know about the Post Office being a prosecuting authority, though. I'm not sure about that.
I think you're probably now aware that between 2000 and 2015, the Post Office bought some 850 prosecutions, resulting in over 700 convictions.
I am aware of that, yes.
Are you now aware that between April 2013 and June 2018, over 600 sub-postmasters were suspended?
No, I wasn't aware of that figure.
Did you have any role in that period, so that's 13 to 18, in giving advice over the suspension of sub-postmasters?
I think it's likely that I did, yes.
So you were aware that although in late 2013, early 2014, prosecutorial activity ceased, the Post Office carried on suspending sub-postmasters?
Yes.
And what was your role in the suspension of sub-postmasters?
I would, so the part of the business that would be responsible for that was a group of people called contract advisors, and that team would contact me as a member of the Post Office legal team from time to time and ask me for my advice, my support, my input into a case they may be looking at.
And so was that whether there were sufficient grounds to suspend?
For the most part, that was their decision, but they might discuss a particular case to see what I thought whether there were. Yes, I think yes is the answer. I'm sorry, yes.
And so when you were giving this advice, although the prosecution activity had stopped, but the suspension activity continued, looking at the matter generally, did you bring into account any knowledge you had? And I think we're going to hear in due course it was an unfolding knowledge, a developing knowledge of bugs, errors and defects in Horizon.
Not that I specifically recall, no.
Do you know whether corporately the Post Office brought any developing knowledge that it had into account in that period? I.e., we've stopped prosecuting people. Mm-hmm. We're carrying on suspending people. Mm-hmm. We may be relying on Horizon data in order to suspend people. Should we be doing so?
I'm not aware of that, no.
You make a point in your witness statement on a number of occasions that you were not and are not experienced in matters of criminal law, is that right?
I would describe myself as not a criminal lawyer.
When you were giving advice to senior executives and others in the Post Office, did you make that explicitly clear to them?
I may not have done.
And why would that be?
Certainly when I joined, there was a specialist criminal lawyer. I had been...
Was that John L. Singh?
Yes, that's correct. I had been hired to attend to civil matters, and I, certainly to most of my colleagues, it would be well known that I wasn't a criminal lawyer and had no background or experience in criminal law matters.
And when you say colleagues, do you mean legal colleagues?
As my first, yes, I did mean that.
I'm thinking about your clients, in inverted commas, even though you're an in-house lawyer. To what extent did you make clear to, let's restrict it at the moment, to senior executives to whom you were giving advice, that you were not a criminal lawyer, or you were not, using my formulation, experienced in relation to matters of criminal law?
I don't recall expressly putting that disclaimer on things.
You mentioned Mr. Singh, so by the time you joined in August 2012, I think he was the head of criminal law in the Post Office, is that right?
I think he was our only in-house criminal lawyer.
Yes, and I think he was described as the head of criminal law, even though he was the only one.
I don't recall him being described that, but...
did you share offices with him?
Yeah, we had an open plan office, so yes, we shared that space.
He's given evidence before the inquiry and is due to come back. He's made a number of statements in emails and in correspondence which might reasonably be described as demonstrating disdain for sub-postmasters. Was that an attitude of mind which you observed in him at the time?
No, I wouldn't have said that, no.
Did you instead form the view that he treated sub-postmasters and the issues that they were raising with fairness and equanimity?
I don't believe I could comment on that. I wasn't close enough to his work. And I certainly didn't observe much interaction between him and postmasters at all.
Yes, I'm not talking about direct interaction. It would have been in what he wrote and in what he said in the office.
No, I don't recall that, no.
So if thinking back, you formed an impression of him, you would have thought he would have treated postmasters fairly, would you?
Again, it's not something that had crossed my mind, so I'm hesitating. If I could phrase it as a negative, I wouldn't have thought he treated them unfairly. I'm sorry, I'm just literally trying to think, trying to cast my mind back to our interaction in the office there, and it's what you're describing isn't something I observed, so it's hard for me to make a positive statement. I'm sorry.
How about this then? A conclusion that may be open to the chairman at the end of the inquiry, when he's heard all of the evidence, is that Mr. Singh had a defective understanding of the code for Crown prosecutors, a defective understanding of his disclosure obligations and the Post Office's obligations, and the duties of candour that a prosecutor owes in criminal proceedings. Over your years of dealing with him, did you have any concerns about Mr. Singh's competence and suitability for the role of head of criminal law at the Post Office?
Sorry, it's quite a long question and a bit in there.
I'll break it down.
Yeah, I think I understand it. I'm sorry. I don't think I'm competent to describe. I said I'm not a criminal lawyer. I don't know the extent to which he was acting compliantly with the prosecutor's code of conduct, for instance. I'm just not able to do that.
So your lack of experience in criminal law wouldn't have allowed you to form a view over his competence and suitability to perform the function he was performing, is that right?
I do not believe I'm competent to do that, no.
More generally, what can you tell the chairman about attitudes within the Post Office's legal team to sub-postmasters who sought to defend themselves against allegations that they'd stolen money or were guilty of false accounting, but who themselves alleged that the shortfalls were due to Horizon? What was the general feeling, if there was one?
I don't think there was a general feeling. I think it's. I'm sorry, I'm really struggling with this because I'm trying to picture the work environment, which is where I feel you're taking me, and it's. And correct me if I'm wrong on that. I don't think.
I am asking you about the working environment. I'm asking you about a 10-year period And I'm asking, was there any attitude of mind towards sub-postmasters?
I wouldn't have thought so, no. There was a lot of discussion at the corporate communication level about postmasters being the heart of the company, and clearly an essential component of the business, the client, the customer-facing part of it.
And did that trickle down into the legal team?
Well, it would certainly trickle down to me. I can't speak for the entire legal team.
They're a commodity that needed to be cherished.
I wouldn't have described them as a commodity, but the cherished bit, I think, was important.
They're individuals, men and women, who needed to be cherished.
Yes,
and treated with fairness at all times.
Yes, they're an important part of the business, yes.
Would that
Very important.
Would that be the esprit de corps of the legal team?
I wouldn't have necessarily said that, because the legal team were doing lots of different things in different spaces. There are parts of the legal team that have very minimal contact with the postmaster community, for instance. And
again, I'm not talking about direct contact with them. I'm talking about in the way that we deal as a legal team with the complaints and concerns that they are raising, the sub-postmaster community. How, as a legal team, do we respond to them? Give us an insight, please, into the feeling within the office.
I would have thought neutrally. What we should be doing is that no presumption either way. What is the case? What is happening here? What is going on in this particular branch? I would have said that. I would hope that was the attitude.
So no predetermined mindset, a position of strict neutrality between the sub-postmasters on the one hand and the post office on the other.
I think I can only speak for myself with that, but that's something I would hope I had done.
Before we get into the dozen or so specific topics that I need to address with you, can we take a step back and look at the written evidence you've given to the inquiry and then some of your conduct at the time? In terms of the written evidence you've given to the inquiry, would this be a fair summary? In your witness statement, firstly, you do not accept that you did anything wrong.
Have I said that?
No, a summary means that you don't read out each word or don't read out the specific words. You summarise. And I'm asking, over 100 pages, you don't say anywhere that you did anything wrong.
I think I have said I did something wrong.
What was the thing you did wrong?
Well, I'm sure I've done others as well. Over 10 years, I don't think I could have batted perfectly. And I wouldn't want anybody to have the impression that I think that. Things have gone wrong, and that's why I'm here.
What's the thing that you think in the witness statement?
Certainly in the witness statement, I missed a reference to the possibility for remote access.
In the Deloitte report?
In an early Deloitte report,
okay,
yes.
So you inadvertently missed a sentence or a paragraph within a Deloitte report.
Correct.
Which spoke about remote access in 2014.
Yes.
I think that's the only thing. I didn't read that as you saying you did anything wrong, because it was an inadvertent slip.
I'm sorry. Wrong is a very broad word encompass. I'm sorry.
Okay.
Could you be a bit more specific? I'm sorry. I'm sure I've done things wrong, but it would be helpful to have an understanding of when or what it might have been.
Well, let's look at it this way. In your witness statement, you either state or give the impression that you acted appropriately and in accordance with your professional duties at all times. Correct?
That was certainly my intent and my endeavour.
I don't think you identify that any other person did anything wrong.
I don't believe that's my role to judge.
Well, it's not necessarily judging, is it? It's maybe talking about the conduct of others without passing judgment on them. But it's right, isn't it? In your 137 pages, you don't identify that anyone else did anything wrong, other than inadvertently missing the sentence in the Deloitte report.
No, I don't believe I have done that in my witness statement. No, I don't believe I have.
And you don't offer any apology to sub-postmasters in your witness statement, do you?
I've certainly tried to in the first paragraph.
Well, let's look at
third paragraph.
Let's look at the attempt. Then, is it paragraph 3 on page 2?
Yes.
Let's just read that to ourselves. Was that the attempt at the apology you were referring to?
Yes.
Well, you offer deep regret at harm caused by events, rather than harm being caused to sub-postmasters by people, or harm being caused to sub-postmasters by people in the post office, or even harm being caused to them by the post office. You offer regret that events cause people harm, don't you? Not people cause them harm. Is that as far as you were prepared to go?
No, it was my attempt to summarise what is quite a large undertaking in
Yeah, you probably thought about this carefully, this paragraph, didn't you?
I hope so. Yes. I thought carefully about most of, I hope I thought carefully about all of my statement. But yes, it's important. I believe it's why we're here.
And that's as far as you're prepared to go. Express regret that events cause people harm.
I mean, I will go as far as say, if I have caused somebody harm, I'm deeply sorry. That's not why I...
But again, you haven't identified in your statement that you have caused anyone harm or done anything wrong, have you?
No.
You don't identify any reflections or things that ought to have been done differently, do you?
I tried to respond to the Rule 9 request I had.
Yeah.
Sorry, I wasn't...
We ask people whether they have any other reflections they wish to give.
I conclude with a reflection.
Let's look at that. Paragraph 255 on page 131. This is the part of the statement where people address the inquiry's question. Have you any other reflections or things that you wish to say? An open question. And you say you regret the various processes intended to resolve postmasters' civil law-based complaints have not achieved that resolution, and you hope it happens soon. Is that your only reflection?
Actually, I think it's an important one because it's not the only one. I think there is another. But this has gone on a long time, and certainly I can only speak for me, but I would never have wanted this to have lasted this long for anybody involved. I think at the beginning, so back at paragraph 3, I do say I hope this process helps people find closure, and I must say I hope for myself personally too.
Well, thank you for that. Can we take that down from the screen and examine a miscellany of issues before we look at the substance of some points to try and see whether they assist us in determining the nature of your role in all of this? Can I start, please, with your role in the development, pursuit, and management of a narrative in the media by the Post Office? Can we look, please, at paragraph 169 of your witness statement on page 84?
Yes.
Page 84, foot of the page, para 169. under a heading engagement with the media, and you say the Post Office's communications team was responsible for its engagement with the media. I was typically the contact for comms within Post Office's in-house legal team if they felt they needed legal support, which could range from ad hoc reviews of statements they were proposing to make to legal advice in respect of proposed broadcasts. I would arrange external legal support where that was required, usually from Cameron McKenna, who I have been introduced to shortly after joining Post Office. My role as an in-house lawyer was one of legal risk manager, and this was my focus in the Post Office's engagement with the media. Thank you, that can come down. So would it be right to describe you essentially as the point man for media relations in the Post Office's legal team?
I think that's fair, yes.
And there was extensive involvement by you and other lawyers in the Post Office's media relations, wasn't there?
On some of these matters, yes.
Can we turn to paragraph 175 on page 86? Sorry, page 88. You set out your understanding of the Post Office's, quote, general attitude and strategy at that time towards the media and its aims in dealing with them. Was that the media could and would report on the Post Office. It was therefore important to maintain an open dialogue with journalists so as to get an insight into what they might say and try to ensure they reflected the Post Office's position, with matters only being escalated to formal legal intervention if it was felt essential to ensure a balanced presentation of the Post Office's position in the finished publication. Would you agree that that paints a benign or neutral picture of the Post Office strategy in relation to media relations?
I can't comment on what it portrays. I would not have described Post Office as necessarily benign with its media-facing public image.
How would you paint or describe Post Office's media strategy so far as concerns Horizon?
I wasn't responsible for setting strategy, so I would have taken instructions from the communications director.
What was your understanding of it?
I think it's, particularly with the Horizon matters, Post Office felt it had its side of the story to tell, and I think there's a feeling that people weren't interested in hearing it or engaging with it, probably is a better example, a better word.
And so what was its strategy?
I don't know. That would have come from the communications director.
You were engaged in that strategy yourself, and you had no understanding of what it was. Is that right? I
supported it. Strategy comes from the internal clients, and the legal team would help give effect to it.
Did they tell you what the strategy was?
I'm not aware of it. Like, if you think that we have strategy documents and clear objectives on some matters, I don't think I saw something quite like that for these matters.
Never mind the written document, an understanding of what the Post Office's media strategy was. If you were giving effect to it, how would you know what it was?
Well, I was giving effect to the instructions on a particular matter. I wasn't responsible for setting media strategy.
I haven't asked you whether you were responsible for setting a media strategy. That's a different question.
I'm sorry.
I'm asking what your understanding was of the Post Office's media strategy so far as concerned Horizon.
I can't tell you because I'm not aware of one. What I did do is help Post Office respond to certain media inquiry activities. The most, I guess, prominent of that being the Panorama program. I helped assist that. Where that sat in Post Office's strategy, which may have issues of brand positioning, etc., behind it, I'm not sure. Okay. I can't speak to that. I'm sorry.
Okay, if you didn't have an understanding of what Post Office's general attitude and strategy towards the media was so far as concerned Horizon, can we look at some examples of how you approach the media in practice? And I stress these are only examples. Time doesn't permit me to go through all material. Can we start, please?
So just before, I'm sorry if I can, I'm struggling with these questions a little bit. Can I understand what you mean by strategy? Because I'm worried we have a disconnect, and I do want to answer the questions properly.
I haven't got my dictionary with me at the moment, Mr. Williams, but I would understand, and I intend by my questions, the word strategy to mean as follows: a pre-designed plan that has aims and objectives. I'm making this up on the hoof. That has aims and objectives. That's a strategy in my mind. Does that help you?
Yeah, it does. Thank you. And I'm sorry.
Well, it's just you use the word here.
Yeah,
see.
I appreciate it. I'm sorry. I'm sorry if that's my poor use. I just want to understand, is it I'm sorry, I'm interrupting your question, please.
See, should paragraph 175 read, I did not have an understanding of the Post Office's strategy towards the media?
Following this discussion, I think it may have read better. My understanding of Post Office's general approach at that time to the media would have been, and I apologise if I'm sort of getting into sophistry or anything like that, but the pre-designed plan, I would have accepted if we'd had something like that, to have had that articulated or presented to me or made clear to me. And I don't recall having that, and that's why I've been struggling. I'm sorry.
Let's look at some examples then, rather than engage in sophistry. Poll 00101923.
While that's coming up, Mr. Williams, can I just be clear? Was this point man, to use the expression role, something that you assumed more or less as soon as you joined the Post Office, or was it later in time than that?
Thank you, Simon. It was pretty much at the beginning. I helped with something unrelated, probably certainly within the first 6 months of my time.
Fine, and so you if I can put it in this way, that part of your work was something that began shortly after you started and continued right through the period that Mr. Beer has identified.
That's correct, sir.
Fine, thanks.
Can we start, please, by looking at page 3 of this document?
I'm sorry, I recognise this and it's quite a long email train. Could I have a bundle reference, please?
E51.
E51. Thank you. Thank you.
If we look at the foot of page 3, we can see an email from Nick Wallace, the journalist, dated the 16th of December 2014.
Yes.
To Mark Davis. He was essentially in charge of Post Office's media and communications, is that right?
Yes.
And Mr. Wallace says, "Hi, Mark, I wonder if your colleagues could help me with a few queries." And then he starts setting them out. Yes? And this was, I think you'll recall, in the run up to the One Show broadcast.
Yes.
Thank you. And then if we go up the page, you'll see Mr. Davis passes it to a wider group of people, including you. Hi, another email from the BBC, now raising a series of new questions. Yes? And then if we go to the foot of page 2, we can see you replied, 16th of December, 2:16, Rodric Williams wrote, and then if we go to the top of page 3, you say, "Without having read them closely, only that this is getting ridiculous. We're being asked to address an ever-expanding range of serious issues on a piecemeal basis with constantly shifting goals in an attempt to get Nick Wallace a story which is, quote, news. On the upside, they suggest we're starting to land our points. This line of inquiry is focused on the user-friendliness of Horizon, not on the accuracy of what it records or what we do with that information. I'll revert on the substance shortly. And then if we go, please, to page 1, at the foot of the page, your further reply to the same group of people, again on the 16th of December at just after 4 o'clock, so it's about an hour and a half after your immediate reaction. And you reply to your colleagues in detail on what's said, if we scroll down. And you say, hi, my substantive responses to Nick Wallace's latest questions are embedded in red. And you essentially go through Mr. Wallace's email and write red paragraphs or text in red against what he has said. Okay?
Correct.
If we go back to his email there, they don't show up in red, but I can tell you which ones they are because I've compared the text next to the original of Mr. Wallace's email. If we scroll back to page 3, please. At the foot of the page. So what Mr. Wallace wrote was, hi Mark, I wonder if you or your colleagues could help me with a few queries. When was the last time the Post Office did any research into how satisfied or otherwise sub-postmasters are with the Horizon system? It would be very helpful to know the scope of that research and its results. And then you wrote, Post Office constantly receives feedback on Horizon from its tens of thousands of users through a variety of sources. And then over the page, the primary sources are the MBSC, Horizon Service Desk, Branch User Forum, and NFSP. Feedback is also delivered through a variety of business as usual processes. Next paragraph, that feedback is then implemented through regular reviews and upgrades. Ultimately, though, any feedback has to be considered in the context of the entire user base. We wouldn't roll out a likely costly system change because a few agents asked for it. No business would. And then you wrote this. We don't need to do research on Horizon. It's the system we provide to our agents and require them to use. If agents don't like it, they can choose not to provide services for us. The vast majority of our agents and other users work with it just fine, and we're not required to bespoke our point-of-sale accounting system to the whims of each individual agent. In relation to your reply, we don't need to do research on Horizon. It's the system we provide to our agents and require them to use. If they don't like it, they can choose not to provide services for us. Was that your view? Sub-postmasters could either use Horizon or leave?
Yes. Because
like it or lump it?
No, not necessarily, but it is the system that is used across many thousands of branches and I think tens of thousands of terminals. That is the system that Post Office provided.
Well, it's obvious it's the system that the Post Office provided. That's just stating a fact. What you've done is gone further. You said we don't need to research Horizon. They can either use it or go away.
But I was commenting immediately above. It makes it quite clear we do actually receive feedback. I think by this is market research on users, that's it's just saying we don't need to. I don't believe there's an obligation, and I'm speaking as a lawyer, I don't think there's an obligation on Post Office to do that.
But was this part of your thinking in your time in this decade? If agents, if sub-postmasters don't like Horizon, They can just down tools and leave. That's their remedy.
Well, I don't think that's capturing what I've said here. I have to say I can't exactly remember what my mindset was in
Well, you agree this is what
2014. But sorry,
that's what it tends to suggest, isn't it?
sorry. What I'd say is the vast majority of the network was using the system fine. On a network that scale, it's impossible, I would think, to bespoke it to each individual's preferences.
Well, it's not their preferences. You call them the whims. Is that what you thought these sub-postmasters were complaining about? That was the basis of their oral and written complaints? Whims. A whim meaning an eccentric flight of fancy.
That is the word I used at the time.
Yes, you understand it to mean that. A whim.
Well, yes, yeah, that's the word.
Did you think sub-postmasters were on eccentric flights of fantasy?
No.
Why did you use the word whim?
Because it struck me as being possibly very bespoke, very individualised requests for personal preference. But I used the word whim. And I think in doing that, I was trying to trivialise the specific complaints being raised.
Is this as an example of what we read about in your witness statement, where you said that the Post Office's approach and strategy was to maintain an open dialogue with the media? You thought saying something like this back would help, did you? This was a comment internally to colleagues. I wasn't saying this is what the response. What's the purpose of saying it to colleagues then? It's to help in the formulation of the response.
Correct.
Is this part of the strategy and approach that you described in your witness statement of at all times maintaining a willingness to maintain an open dialogue with the media?
I don't think they're connected yet, because the way it works is, the way I recall it working for us, is things are circulated for input, views are heard, and then a position taken, at which point that feeds into what is taken back to the media.
Let's move on. We can skip the next paragraph, where you draw an analogy. We go back to some text that Mr. Wallace wrote. So his question was, is your statement about the vast majority of sub-postmasters, and the point there, the statement he is referring to is a statement that the Post Office put out in an earlier reply. Is your statement about the vast majority of sub-postmasters not having any problems with Horizon based on customer feedback or purely on the volume of successful transactions? And then we see your comments. Our customers don't use Horizon. If by customers Nick Wallace means agents or Horizon users, we could point to the churn rate of agents, i.e. if agents aren't happy with Horizon, they can leave the network. That's the same point that you made above. I think this would only show general churn, i.e. it wouldn't distinguish those that left because of Horizon as opposed to any other reason, e.g. retirement. Still, if the network is fairly stable, a low churn would suggest it's only a minority of agents that are unhappy with the system, which is consistent with what we've seen through the scheme. I get the sense from speaking to a number of sub-postmasters that they don't like the system, they don't trust it, and they live in fear of what the Post Office might do if they get something wrong with it. This is Mr. Wallace speaking. It may be because I only come into contact with sub-postmasters who are having problems that I keep hearing this. So it would be useful to know the other side of the coin. You say, same points as above. On the they live in fear point, it is wrong for an agent to deliberately cover up branch losses and falsify the figures the agent enters into the system. So in these paragraphs, in your response to your colleagues, you're making the same point, aren't you? That the measure of Horizon's reliability or success can be seen through the number of sub-postmasters that are leaving the business.
I think it's rather the other way. It could be seen by those who are staying within the business.
I.e., it must be a good system, because otherwise more would leave.
Or at least an acceptable system.
Was that your best evidence base when you were writing this 2 years in to your 2.5 years into your role for the reliability of Horizon, the number of sub-postmasters that were leaving the post office?
No, I'm looking for. I was looking for things that could contribute to the discussion. What was, and maybe this is getting to, well, it's not quite a strategy. I'm sorry. There was, my recollection is that there was a feeling that the complaints being raised about Horizon were being raised by a small number, a small proportion of the network, and that it was being used successfully by the vast majority of the network every day, aggregating up to, and I think I can still remember, hopefully, the numbers, 6 million transactions a year, 6 million transactions a week, 2 billion a year across the 11,500 plus or minus branches. And we were seeing a very small number of complaints.
And he's asking for the data, isn't he? In this last paragraph, if you have any data which shows the vast majority of sub-postmasters love using Horizon and trust it implicitly, it would be useful to have that information. So he's asking the very question that you've just referred to. And then let's see what your response is over the page, please. This is puerile. Why did you think that Mr. Wallace's question, if you've got data that shows that sub-postmasters like using Horizon and trust it, it would be useful to have that information? Why did you think that was puerile? Puerile meaning childish, immature, or petty?
I'd say looking at it today, it doesn't feel puerile, so I think that may.
I'm sorry?
I think that may just be a very poorly worded email.
Which word did you intend to use instead of puerile?
I'm sorry, it's on two screens.
Yeah, we can look at the bottom of the third page and the top of the...
Yeah.
So that's it. Question at the bottom of page 4.
I think I know why I'm saying it now. Sorry, that's one. You know,
You said that-
FMRs love using Horizon and trust it implicitly. It's a very high bar. I don't know too many people who really love their computer systems. I'm sure there are people, but I think that's what the expression is going to. You know, do we have data that says people love using Horizon?
He's asking, isn't he, for data that backs up a statement that the Post Office made that the vast majority of sub-postmasters are not having any problems with Horizon.
Well, no, he is there asking he is asking for evidence that postmasters love using Horizon and trust it implicitly, and I think I read that as setting an impossibly high standard for us to have evidence, information that would show that. I don't. That's what I think I'm saying there.
You carry on. The best I can think of is to show that agents aren't voting against Horizon with their feet. That's the third time you've referred to that.
Yes.
Was that the best evidence?
I don't know. Certainly when I wrote it was the best I could think.
Overall, would you agree that without focusing on the individual paragraphs, in this part of Mr. Wallace's request, he's asking for some data, some material that backs up a statement that the Post Office have made that the vast majority of sub-postmasters are not having any problems with Horizon.
I'm sorry, could you repeat that?
Yeah.
Sorry, I was reading.
In this part of his request, he is asking generally for some evidence, some data, some material that backs up a statement that the Post Office had made that the vast majority of sub-postmasters are not having any problems with Horizon. And overall, the best you can come up with is that they're not leaving the business.
That's the best I can come up with. I think earlier on we saw there was references to the MBSC, coal log data, etc. I think that would be better management information than churn rate, which was another strand of management information that may support, I guess, user acceptance, if not happiness.
Can we move on to some of your other contributions to Post Office's media responses? Poll 0015-0306. Can we look at page 2, please?
Sorry, I think this is another one that may have been, I sort of wasn't in the core bundle reference.
E86, if you want to look at it in hard copy.
E86, thank you.
So I should just explain to you that the little delays that are occurring are because Mr. Williams has said that he wants to be given the tab numbers in the bundles and read the documents in hard copy rather than looking at them on the screen.
Yeah, I've understood that from the exchanges, Mr. Beer. Thank you.
I'm grateful, sir.
E86, and look at page 2, please. And if we scroll down, please. We see again the Mr. Wallace email. Yes?
Mm-hmm.
Can you see that? The 16th of December one. And this has got no writing on it. Okay? So it's the same originating email.
Oh, great, thank you.
But this chain goes off in a different direction. Okay?
Thank you, appreciate that.
If we scroll up, please. We see Mark Davis's sending it on email we saw earlier, yeah? And then scroll up, please. We see a reply from Patrick Book. Who was he?
He was is a colleague. I don't know what his title was at that time. He had worked, I think he had come into Post Office to work on the mediation scheme, and I think is now he's certainly in the communications team. I think maybe the public affairs director, but I'm not certain of that.
At the time, I think his title was Government Affairs and Policy Director. Would that sound right?
That does sound right, thank you.
Let's look at what Mr. Book thought about Mr. Wallace's email. Apart from its breathtakingly facetious tone, this looks to me to be clutching at straws a little. That some sub-postmasters don't like the system is inevitable. I don't particularly like working in Old Street with its rodent problem. Living in fear is going too far in my view. They chose to sign a contract to provide services in an honest and diligent way rather than living in fear. Would it not be better to do something else? You agree that he's there expressing the same sentiments as you, albeit you hadn't written them yet. I.e., put up with the system or leave.
No, it's an option.
He says, I like this email that Mel, that's Melanie Caulfield, sent me earlier from a sub-postmaster, and then he reads it, then he sets it out. And then in conclusion, at the foot of his email, he says, I'm not sure it merits more than a cursory response. Then if we scroll up, please, you say to him, I swear you're the only person I've met more cynical than me, and then by some considerable margin. He replies to you, well, thank you, sir. I take that as a serious badge of honour, smiley face. And you say, as intended. Did you treat this as a joke?
No, far from it.
Was this attitude bravado by you? A competition between you and Mr. Burke, the Government Affairs and Policy Director, on who could be more cynical about sub-postmasters?
No.
Why did you exchange these emails then?
When you're working under pressure, at times, sometimes you write an email that, when you look back at it 11 years later, sorry, 9, can't do the maths, 9 years later, you regret the expression. But I think emails exchanged just between two colleagues like that from time to time occur.
So we to put this in the banter category, top bants between mates.
I would say yes. Yes.
The truth of it is that you adopted the same attitude of mind, didn't you? We're deeply cynical about all of these sub-postmasters. The best thing they can do is if they've got any complaints about our system, they can leave. That was your and his attitude of mind, wasn't it?
No, I think you're reading too much into an email exchange there, with respect.
Why didn't we see in these emails some self-reflection? Have we got any surveys of whether sub-postmasters have difficulties? What do the statistics show on the number of calls made to the various help desks that we offered? Is there an analysis of those? Are there any levels of satisfaction with those? What proportion of complaints about Horizon are successfully remediated? That's what he was asking for, that kind of thing, wasn't it?
Well, I'm sorry, that's a list I think you've read. That's not in there, but I imagine it is along the lines of, well, I don't know what Nick Wallace was asking for there. He asked for what I saw, data of people loving the system and trusting it implicitly.
Right, so you focused on the love bit and thought narrowly.
In the entirety of the
Have we
email.
got any surveys or data that shows that Horizon is loved by sub-postmasters? No, and that's a puerile question, end of story.
No. When you look back at the exchange, you can see other people have contributed to it, and there is reference to NBSE call log data and the like that provides sources which could be explored further if that's the direction that would be taken in response to this.
Can we look, please, at poll 00101968, B202. And can we go to page 10 at the bottom, please? Page 10 at the bottom. Thank you. Sorry, behind with the bundles.
And sorry, what is the tab?
Do you wish, Mr. Williams,
yes,
to look
please.
at this in a bundle?
Yes, please. Sorry, my bundle broke open, so I'm sorry. Right. I'm trying to put the paper back. Which tab, please?
It's B202.
B202, thank you. I'm so sorry. I'm sorry, I've only seen these this morning, so I'm still familiarising myself. Thank you. Thank you, sir.
Page 10 at the foot of the page and over to page 11.
Yes.
This is a document you exhibited to your witness statement.
Yes, thank you.
You'll see that Jane French, who was then, I think, the BBC's current affairs editor, sending an email on the 7th of January to Mr. Davis, copying Mr. Wallace in. And so this is after the One Show programme had been aired and is instead about a forthcoming Inside Out programme. And if you just scroll through, if we just scroll down, please, she says to Mr. Davis, "Thank you for your input. I'm writing to invite you to give us a filmed interview for our current affairs, our regional current affairs programme, Inside Out, that will be reporting the subject on the 19th of January on BBC One. So this is 12 days in advance." And then if you just scroll through it, rather than reading it in detail, she sets out a summary of the issues to be covered in the programme. Can you see that?
Yes.
And then if we scroll on still further, it's a relatively detailed summary. And then a series of questions. If we go to page 8, please. And scroll down, please. We'll see that this gets forwarded to you.
Yes.
And we can see your reply on the 7th of January. You say, "I haven't yet looked at the detail of the email, but see that the BBC want to film. There's a lot happening next week," next paragraph. And then not really a legal issue, I know, but given the BBC's approach to date, the close engagement it has with the JFSA and the timing of the piece, I smell a rat. What was the rat that you smelt?
The timing seemed...
Smelling a rat means that somebody's trying to deceive you or harm you by artifice.
No.
What did you mean by you smelt a rat?
It looks like it's organised. I think something is up.
What was up?
Well, the timing of this seemed to be well aligned to put pressure on Post Office.
Why was there a problem with the BBC reporting issues with the Horizon system and with the Post Office being given an opportunity to respond?
There's nothing wrong with that.
What was the rat then? What was the deception being practiced?
I've said I don't think any deception is being practiced. That's not what I've said.
What were you intending to say by, given the approach to date, the close engagement the BBC has with the JFSA and the timing, I smell a rat? What did you think was going to happen?
I'm sorry, I thought I'd answer that. The timing seemed convenient.
Convenient to who?
The postmaster complainants.
Right. And therefore?
I'm sorry, you've lost me. You keep saying, I don't think there's any deceptive. I'm not using that in this respect. That's your interpretation. I'm sorry if you've...
What did you mean by smelling a rat?
I'm sorry, I've tried to answer that a couple of times. It's the timing.
I'll try a third time then. What did you mean by smelling a rat?
That the timing.
What did you think the BBC was up to?
They're going to put out a piece that was timed with events that may have taken place at a working group face-to-face meeting. It looked like there was building up to a media broadcast or something along those lines that would have advanced the postmaster's complaints.
Can we turn to poll 00105856? That's tab E57. Can we start, please, by looking at page
sorry,
4,
I was looking at E5.
57.
Thank you. I'm sorry, I'll go straight to the bundle in future. I'm sorry. Thank you.
If we just scroll down, you'll see it's an email from Melanie Caulfield, who was in the comms team. Is that right?
Correct.
And if we scroll up, please. She says, we can see who this is addressed to when we look at the reply all later. Now they've finally revealed the names of interviewee experts in inverted commas, including Charles McLaughlin, expert defence witness in the Misra case. I think we should use this to go back to Kerry. And we can see from the context of the email as a whole, this was the beginning of a debate on the approach that should be taken to Kerry Thomas, who I think you may remember in mid-2015 would have been the editor of Panorama. Yes?
That's not something I recall, but no.
In any event, Mel, is talking about a proposed contribution by Professor Charles McLaughlin, yes?
Yes.
And then if we go to page 2, please. At the bottom, we can see what the title of the email was. Another throw of the dice at Kerry Thomas. And you say, I want to think about this overnight, but I'm not inclined to offer anything directly because of the CCRC. Sorry, but we've learned a lot more about the programme since I sent my last email on this. And then over the page to the top of page 3, instead, we could use as a hook the BBC guidelines in and around relying on people who are not impartial, which McClacken patently is, especially if they have an axe to grind. And then you set out a proposed reply to the BBC. In what respect did you think Professor McClacken had an axe to grind?
So the expression axe to grind was one I gained from Post Office media lawyers. That it's a term of art. I became aware of a type of contributor who may have a vested interest in the piece.
So it was a term of art, axe to grind?
That's my understanding, and that I think was my use of it there.
And does that mean that anyone who had a vested interest, including, for example, sub-postmasters, or indeed the Post Office, couldn't make a contribution?
No. What I think it lent itself to, and I'm sorry, it's been a while since I've sort of looked at this sort of material on that. It just meant, I think under the BBC guidelines, that their contributions needed to be treated with greater care. I'm paraphrasing, and apologies to BBC if I'm misconstruing that or misstating it, but that's my recollection.
So it was to point out to the BBC that they shouldn't regard Professor McLaughlin as impartial and to remind them of their guidelines in that respect. Is that a summary?
That's probably fair, yes.
Thank you. Can we move on, please, to poll 0015-2725? I think that's E91.
Thank you.
And go to page 2.
Sorry, did you say?
E91.
Yeah, I'm sort of looking at that. That doesn't seem. I have poll 152725. This seems to be different.
Yeah, poll 0015-2725. Tab E91.
I have a I'm sorry, I beg your pardon. I do have a.
Yeah, the double-sided pages.
Thank you. I'm sorry.
On the 3rd of July 2015, Mel Caulfield wrote to you, not sure if any use, was just checking on something, came across the below from Kumarich Solicitors, and you'll see that she cuts in something in the second paragraph from that firm of solicitors' website. In 2013, when interim report came out, it just confirms they're looking at appeals, then regarding the cases they had, I think Hamilton and Misra, but can't remember, on the basis of information from the investigation. So you thought it might be of use to you at some point. It also makes clear, case-by-case basis, a point I'm still trying to make to journos and politicians understand. How can anything be decided in any other way? And then back to the first page, please. Foot of the page. You say, thanks, Mel. You might recall that the first one show piece at the end of last year interviewed a criminal solicitor who may be from that firm. It's telling they've not been involved in any appeal. And yes, each case has to be looked at on its own facts. And then scroll up, please. She replies to you, yes, that was Izzy Hogg, who's from this firm, I think. I believe she gave the incredible quote, that, quote, they don't look like criminals. From a media point of view, I'm astounded that no one ever seems to ask the defence lawyers why their clients pleaded guilty and why they've not tried to appeal. Seems it's only the Post Office who get asked the questions. Oh well, sunny weekend ahead, hopefully. And Panorama Story still not showing in the schedules. Was it a commonly held view within the Post Office to think that it was only the Post Office who got asked the questions?
I can't speak for Post Office.
Okay, the people with whom you dealt within the Post Office.
I don't recall that. No, I mean we were being asked questions, and I'm sure other people were as well.
Was it a common view within the Post Office that focus should instead be asking the defence lawyers why their clients pleaded guilty and why they've not tried to appeal?
I'm sorry, could you repeat that?
Was it a common view within the Post Office that the focus should instead be on asking defence lawyers why their clients pleaded guilty and why they had not tried to appeal?
Again, I don't think I don't know who else was in Post Office, but that's not something I was turning my mind to, I don't think.
Was there a view, an attitude of mind that the Post Office was being got at by sub-postmasters and the media?
Maybe not by postmasters, but I think it is probably fair to say we were feeling a little bit got at by the media. I think that's fair.
Can we move on to poll 0015 2777, please, which is the next tab E92. And look at the second page. At the foot of the page. And if we just scroll down a little bit, we can see who Mark is. You'll see that he is a writer of at the Shropshire Star, or at least he was, in mid-2015. If we scroll up to the text of his email, he says, further to our conversation a few minutes ago, I'm following up the story that Second Sight has written to the government, saying that its findings of its report on the Horizon system have been misrepresented. The story is on page 10 of yesterday's Telegraph. I've spoken to Ron Warmington of Second Sight, who's confirmed his concerns have been misrepresented after the minister said Second Sight produced two independent reports, one in 2013 and the other earlier this year, both of which found there was no evidence of systemic flaws in the system. Mr. Warmington has said that the term systemic can only be used when referring to a constant fault. That is why the report said there were no systemic faults. However, he says the report clearly said there were circumstances where a combination of factors could lead to a fault in the system which could account for some of the discrepancies which have resulted in civil and criminal proceedings against the postmasters. Can I have a response? And then if we scroll up, please. That gets forwarded by Melanie Caulfield to some people, not including you, and then gets forwarded by Mark Underwood of the Complaint Review and Mediation Scheme to you. And if we scroll up, please. Keep scrolling. If we go to the top of the page, you say, I'm uncomfortable with the final sentence. We'll look at what that is in a moment. I know we've used it in the draft panorama statement, but I want to think on it overnight to make sure the line to both Shropshire Star and Panorama properly covers the two bugs we identified for Second Sight, which did affect balances. And so if we scroll down, please, you see in the bold text there the proposed reply that Miss Caulfield was going to give back to the Shropshire Star. And you had said you were uncomfortable with the final sentence, despite it being used previously. The final sentence is, this work, that's over 3 years there have been exhaustive investigations into a very small number of complaints. This work has provided overwhelming evidence that the computer system was not responsible for the missing money in these post office branches. Why were you uncomfortable with using the sentence, this work has provided overwhelming evidence that the computer system was not responsible for any missing money?
I think the use of overwhelming is a very, very high bar, and it's not an exact one, but a very high one. And we should be trying to make sure that we don't make statements that can't be substantiated, corroborated, or defended.
Would a simpler explanation for you being uncomfortable with that final sentence be that it wasn't true? No, I don't know that it wasn't true. As I say, it was just a very high bar and capable of different interpretations. This is a media line, I think, and I'm naturally, I'm cautious. It's you're being hostage to fortune when you set your stall out that high. So it was the strength with which the sentence was expressed rather than the substance of what was being said that you were uncomfortable with?
Well, and also, I guess the conclusion. You know, I'm not sure that would necessarily have led to that. I'm not sure that it didn't. I just think it was too uncertain. I think, or potentially indefensible.
Was it because by August 2015, this is a matter we'll look at later today and maybe tomorrow morning, that you knew that the work of Second Sight hadn't provided evidence, let alone overwhelming evidence, that the computer system wasn't responsible for missing money?
Sitting now, I can't say that that's a connection, but it may have been.
Okay, I'll move on. Poll 00113008. This is tab E65.
E65?
Yes.
Thank you. Thank you.
And this is a chronology of the Complaint and Review Mediation Scheme, I think produced by the Post Office itself. And can we go, please, to page 13? And 4 boxes from the top. There's a reference to a meeting on the 4th of September 2015 between you, Mark Davis, and the BBC's most senior executive, James Harding. And the chronology records that at that meeting, the Post Office acknowledged the legitimate public interest in scrutiny of the Post Office, including the BBC. Nevertheless, the Post Office made the point that the Panorama programme was unbalanced and misleading in its presentation of the facts, and that the BBC failed to take up the many opportunities the Post Office had offered, which would have facilitated a fairer programme. And it reserved the right to make a formal complaint to the Trust. But what were the numerous opportunities that the Post Office had offered to the BBC that would have facilitated a fairer programme?
So do you know who the author of this is? I don't. I only received it quite late.
It's
so.
unattributed.
Okay, thank you. I think that there are two offers that I can remember. Well, one was initially for a talking head interview, so a live to camera interview, and another was to share some material from a file relating to a particular contributor to the programme.
Was it those 2 points that led to the view that the Panorama programme was unbalanced and misleading, or was it about the content too?
No, I think it was definitely the content too.
It was the content too?
Yes.
Thank you. So that's an appropriate moment to break, please. Could we break until past, please?
Yes, of course. Thank you very much.
Thank you. Good morning, sir. Can you continue to see and hear us?
I can, thank you.
Thank you very much, Mr. Williams. Just one last document, please, on this topic of media relations.
Thank you.
Poll 00232517, and that's at E104.
104, thank you.
And if we just look at page 3 to get the context. There's an email from Mark Davis to you and others referring to that meeting that we looked at before the break. Rod and I met James Harding, BBC's Director of News and Current Affairs, and Kerry Thomas, Editor of Panorama Today. As you know, Head of Complaints also attended. It was useful to have the opportunity to land our points about the BBC approach and the reality of the cases featured. Grateful for you for attending and his excellent support, and Mel for her pack. Mr. Harding listened and responded positively without making any commitments, as we would expect. We've landed key points. And then if we go to page 2, please. There's, if we scroll down to later on the 4th of September, Mark Davis says, I'd like to review the complaint again. This is the complaint against the BBC that was being formulated. Actually, to make it even more comprehensive, I think we need to formally note the views and involvement of Nick Wallace. And then over the page, please, to page 1. At the foot of the page. That's it. Mr. Davis says, on an email sent to Susan Barty and copied to you, I think we should build out a section, this is in the complaint letter, we should build out a section on Nick Wallace's involvement. In a nutshell, I'd be looking to say that A, Mr. Wallace has clear views which threaten BBC impartiality. B, this point is underlined by the BBC previously requesting that he remove a blog post on this issue. C, we were not informed he was involved in Panorama, which seems a breach of good faith. And D, we know he was involved because he had boasted about it on his Facebook page. In adding this point, I think we should provide examples, Mel has them, outlining where he has gone on his blog beyond journalism and into campaigning against the Post Office. I'd also use this letter to formally question why, when approaching contributors, the BBC have never featured the views of the NFSP. Even if the NFSP has declined approaches, there's on the record footage of George Thompson talking about the issue. At this stage, did you agree that Mr. Wallace held views that it threatened the impartiality of the BBC?
I don't, those aren't my words, no.
No, that's why I was asking you whether you agreed that Mr. Wallace held views that threatened the impartiality of the BBC.
I didn't hold that view. I didn't turn my mind to whether they did or didn't.
Did you turn your mind to whether or not the BBC had acted or not acted in good faith?
Not on good faith, no. I didn't turn my mind to those concepts.
Was there a kind of bunker mentality amongst the senior leadership in the Post Office in relation to Horizon and the media's treatment of it?
I don't know that I can speak for senior management, but I do think certainly where I was sitting, it did feel a bit bunker mentality. Yes, I can't speak for the senior executives.
Were you in the bunker?
Yeah, I probably was. Yes.
Can we turn to a different topic, please? And that's your relationship with external legal advisors. That can come down from the screen. By 2016, you had been legally qualified for 21 years, is that right?
I think so, yes.
And you've been admitted as a solicitor in this jurisdiction for 14 of those years?
2016, that would be correct, yeah, plus or minus.
And you were by that time specialised, an expert in civil litigation?
I certainly had experience and obviously 16 years of it in civil litigation. There's always somebody more expert than me in this field, I found.
Can we look, please, at poll 303 8852. B260 if you want to look at it.
Thank you. Oh, yes. Yep.
This is, if we just scroll down to the foot of the page, an email from Amy Prime, who was a solicitor at Bond Dickinson. And if we go to the top of the page, please, we can see it's her email to you of the 10th of May 2016, copied, amongst other people, to Andrew Parsons, the partner at Bond Dickinson.
Can I just check something? I don't think that date is correct. I think this is, we struggled to find this, and I think, I'm happy to be corrected by somebody, I think that it's using the American date referencing, so I think it's the 5th of October.
Okay, fine.
That becomes, sorry, I beg your pardon, I wanted to clear, and if I'm wrong about that, I apologise, but that's my understanding.
In any event, in 2016, either in the summer or autumn, Amy Prime, a solicitor at Bond Dickinson, was emailing you with a request for instructions on a request for disclosure in relation to Post Office's investigation guidelines. Yes?
Yes.
Can we look at the email, please? She says in the email, and I should say that Miss Prime, who was then recently qualified, had sent a draft of this email to the partner, Andrew Parsons, first, and he contributed to the drafting of it. Documents that the inquiry has make that clear, and that's a matter we'll take up with others later in the phase. In any event, Ms. Prime says, Freeths have requested that we provide them with Post Office's investigation guidelines since 1998, including any revisions to date. In the earlier round of disclosure, we did not provide the guidelines since we wished to confirm whether the documents were covered by privilege. Brian Altman has confirmed they will not be covered by privilege, and as such, the guidelines will at some point have to be disclosed. We've reviewed the most recent version of the guidelines, which were adopted in January 2016, and the prior version, which were adopted in August 2013. Of note, the 2013 version attached password, and then if you scroll up, please, you can see that there is indeed conduct of criminal investigation policy V2 300813 as an attachment. And scroll back down. Of note, the 2013 version attached provides, quote, should the recent second site review be brought up by a subject or his representative during a PACE interview, the security manager should state, I will listen to any personal concerns or issues you may have had with the Horizon system during the course of this interview. Freeths will more than likely use this statement as an opportunity to confirm that Post Office responded to postmasters using stock answers, a point which has already been raised in relation to the helpline, and further could be spun to show that the Post Office was not taking issues with Horizon seriously and were trying to ignore any issues which were raised. Although we may face some criticism later on, we are proposing to try and suppress the guidelines for as long as possible on the grounds that the most recent version is not relevant since it postdates the investigations complained of, and it would require a full disclosure exercise to piece together all historic versions of the guidelines. We thought it would be best to bring this to your attention early. For now, we'll do what we can to avoid disclosure of these guidelines and try to do so in a way that looks legitimate. However, we're ultimately withholding a key document, and this may attract some criticism from Freeths. If you disagree with this approach, do let me know. Otherwise, we'll adopt this approach until such time as we sense the criticism is becoming serious. If you'd like to discuss, please don't hesitate to call. So your solicitors had both the 2013 and the 2016 versions of the investigations guidelines, yes?
Yeah, that's what it seems like, yes.
And indeed, they attached the 2013 version to the email, yes?
That's what it shows, yes.
And they made a proposal that was essentially summarising threefold. Firstly, that the Post Office should, through its lawyers, suppress disclosure for as long as possible. Do you agree?
Yeah, that's what it says, yes.
Secondly, that suppression should be done in a way that looked legitimate to the outside world. Agree?
Yeah, well, that's what it says, yes.
And third, that you were to say, if you disagreed, that disclosure should be suppressed, but at the same time be made to look legitimate to the outside world.
I don't think it quite says that, but that's certainly the gist, yes.
And there's no record of you saying that you did disagree, saying don't do that, it's wrong, is there?
There's no record. As I say, I think I say this in my statement. I did not recall, I have no recollection of this email, which is regrettable because.
Are you used to getting emails from other lawyers saying we should suppress documents?
I'm used to getting a lot of emails.
So
I don't recall reading this at the time. It was clearly sent to me. It was clearly addressed to me, but I do not recall. And the reason why I mentioned the date is when the inquiry provided this to me. I'll be frank. It's a concerning email.
I bet. You searched your emails like frantic, no doubt, didn't you?
Well, I did, and I couldn't find anything around it until the dates were swapped, and I looked around October, and I did indeed receive it. It was in my inbox.
And you didn't reply to it?
No.
You didn't say, no, don't do that.
I did not reply to it, but I do not recall reading it carefully. I don't recall it in any size, shape, or colour.
Well, your actions are the more important thing, rather than your present recollection.
That's fair. Mm-hmm.
What we can say is that you didn't reply.
Correct.
Saying, no, lawyers shouldn't suppress relevant documents. They shouldn't do so in a way that is made to look legitimate. And they certainly shouldn't do so because the content of the document is concerning and might be used by our opponent to make a good argument against us. You didn't do any of those things, did you?
No, I certainly didn't reply in writing. As I say, I don't recall calling either, which is the invitation there. I don't recall any action on this. So no, I did not take any action in response to this.
Had the Post Office given Bond Dickinson instructions to take an approach like this generally to disclosure, i.e. a rigid, hard line approach to disclosure?
No, we had not. I do recall at many stages with disclosure was quite a big issue, as I think does come clear through some of my evidence. Well, hopefully it comes through some of my evidence. And it was a challenge for Post Office because we held most of the documents and would be doing the lion's share of the disclosure. And like all large disclosure exercises, it's a challenge for the claimants who have an idea of what you have but don't know quite what it is because they don't have it. And Andy and I used to talk about if we couldn't do something, what else could we offer that would approximate it? You know, we'd say the no-but approach. That's the recollection I have of our approach to disclosure to it. And as I say, this is inconsistent with that. I accept that, which is why I find it odd.
Why was the Post Office suppressing disclosure of documents which it considered may harm its defence?
Well, the reasons being advanced are in the email. I think this was made before formal disclosure orders, so this is in pre-action stage. But
they'd asked for this. They'd asked for, I think, 30-odd classes of material, and one of them was investigation guidelines. And this had been identified, the 2013 version, as containing a passage that might harm the Post Office's defence. That's the only reason given for not disclosing it.
That's all I've seen there. Yeah.
Is that a legitimate reason for not disclosing a document? That it might harm your defence?
No, not to me, it's not. And I would hope that wasn't my view then either. I don't believe it was, but as I say, I don't recall any reaction to this.
Did you enjoy such a close relationship with your solicitors in the group litigation that it was perfectly acceptable openly to discuss the suppression of disclosure and covering it up by making it seem legitimate in emails of this kind?
I have to say no, and this is inconsistent with most of my dealings on this matter with our solicitors.
But you didn't do anything to pull Bond Dickinson up on this, did you?
On this, no.
Can we move on, please?
Well, in reality, Mr. Williams, this email should have had a prompt response from you to the effect of, you can't possibly do that. That's right, isn't it?
That's what I'd like. When I looked at this, it is quite possible, and I offer this in no way as an excuse, because that's what would have been desirable. The first line is, it says it's not urgent, to consider as and when you get a chance. And as I say, I do recall I was dealing with something very urgent at the time. But I'd sitting here today, I'd like to say I did that, but I didn't, sir.
But I'm right, aren't I? There should have been a prompt reply, and it should have been, you can't possibly do that.
Yes, Your Honor.
Fine. Thank you.
Well, there's another view of it. The penultimate paragraph says, if you disagree, you must get in touch.
Yes.
So it was like a negative resolution. We're going to do this unless you pipe up. And you didn't disagree.
I did not disagree.
Thank you. Can we move on? Poll 304-3169. That's E37. And again, I'm still on the topic of dealing with external legal advisors. Just a bit of context before we dive in. We're now many years later in October 2019, and the Post Office had managed to conduct the Horizon Issues trial, which was concerned with whether there were known errors in Horizon, without disclosing to the claimants and to the court many important known error logs. Okay?
All right, thank you.
Can we turn to page 4 at the bottom, please? We can see your email of the 19th of October. Ben, and this is to Mr. Fote, please find an updated board update. Set out below are the keynotes to address the points from your email on what would it take to get all of the KEL review done by next week, and what is the scope of a Fujitsu audit that would diminish the risk of creating documents that would then need to be disclosed to the claimants. And then reading on. Generally, and I'm afraid there's some text in here in the email we've been provided with that makes it harder to read, but I think we can get the sense to it. You say, I have firmly stressed, or I've stressed firmly, to the HSF and Womble Bond Dickinson teams the importance of this work stream. It's being escalated to Alan Watts at HSF and Tom Beezer at Womble Bond Dickinson to make sure our board's requirements are met, and they were both CC'd. The key legal risk here is the ongoing duty in the GLO litigation to disclose adverse documents, which may not exist or which we may not have been aware of, but for taking the action now contemplated, especially in the context of material we've not previously seen. And then under the heading new KELs. You say Womble, Bond, Dickinson are assessing the risk over the weekend of the 94 newly disclosed high-risk KELs. By the middle of the week, counsel will have reviewed these KELs in detail and given a view on whether they're likely to cause the Horizon trial to be recommenced or judgment delayed. The counsel team being best placed to identify the impact they may have on the trial they conducted. So trial over, 94 high-risk KELs that had been newly disclosed after the evidence had finished, and counsel were looking at, are we going to have to recommence the trial, i.e. hear some more evidence, or ask the judge to delay giving judgment. And then in relation to the other KELs not used at trial, i.e. the majority of the 14,000, around 14,000 new KELs, the key risk of reviewing these is that claimants have not yet asked for the documents. So by reviewing them now, we are doing the claimant's work for them. The legal advice, therefore, is we should not review the 14,000 other KELs unless the claimants ask for them or counsel's review of the 94 high-risk KELs warrants a wider review. And then if you just read the next couple of bullet points to yourself. And then under audit at the end, the best way to mitigate the risk of generating adverse or disclosable documents through an audit is to keep it focused on Fujitsu's litigation support provided to date, with any operational audit to follow once the litigation has been resolved and its associated disclosure duties continued. You'll see that in the course of the legal advice that you gave to Mr. Fote there, you said, that can come down from the screen, thank you, that in relation to the 14,000 odd new KELs, there was a risk, if Post Office reviewed them, that you were doing the claimant's work for them because the claimants hadn't yet asked for those documents. Yes?
Yes, that's what that says.
Was that an approach that you took to disclosure generally? Unless the other side asks for a document, there is no need to review your own material to see whether it meets the test for disclosure.
No. Sorry, I want to make sure I'm saying no to the right thing. That was not my understanding of our approach to disclosure in the litigation.
Was it your approach to disclosure of the known error logs, the around 14,000 of them, at this stage?
No, it was. It depends. Are you talking about the new KELs or the?
No, I'm talking about the 14,000 that were not the 94 high-risk ones that have been disclosed.
So I'm sorry, I'm confusing myself now. Sorry, could you ask the question again, please?
Yes. Was it then your approach that in relation to those 14,000 known error logs, a relevant consideration was whether the claimants had asked for them or not?
In trying to work out what Post Office was to do with these, clearly thought it was a relevant consideration.
Why is that a relevant consideration?
Is it something that the business wants to do?
In law, why is it a relevant consideration?
Sorry, you'll lose me. What is whether the claimants do it or not? We had operated. No, so we have a duty to disclose adverse documents. That's my understanding.
And can you discharge that duty without looking at the documents?
I suspect it'd be difficult to.
And that's what you were proposing not to do.
But I don't necessarily think it's wrong because the disclosure was focused to whatever had been ordered.
None of this had been ordered.
But across the entire business, not every corner was turned. But you'll also see, so doing the claimant's work for them, I'm trying to think why I said that.
Let's have the document back up on the screen.
I have it in front of me.
Poll 3043169. Scroll up, please. Under new KELS, second bullet point. First bullet point, you deal with the 94 that have already been disclosed, and counsel are assessing whether this is going to cause some rather catastrophic consequences for the trial.
Yes.
That's already taken place.
Yes.
Second bullet point, in relation to other KELS, the 14-odd thousand, the key risk of reviewing them is that the claimants haven't asked for them yet. By reviewing them, we're doing the claimant's work for them. My question's really simple. You were suggesting that there's no need to review your own material to see whether it met the test for disclosure, weren't you?
That's but I'm also saying that, so that seems to, on the next bullet point, that seems to be supported by legal advice, and I'd like to, I don't remember that advice, but that's the sort of thing I'd like to refresh myself on, because that seems to underpin what the statement above it is, and I'm afraid I don't recall it.
So you saying that the next bullet point, the legal advice, is not referring to the legal advice that you are here giving in this email. It's referring to somebody else's legal advice that you're regurgitating.
Quite possibly. I'm struggling with and I've highlighted it, so I've clearly brought it to the attention. I'm trying to work out now why I wrote that in the way I did, and I think I say sort of quite often what I do, and in a circumstance like this is highly likely I'd have been doing it, is that this issue of the new late found KELS was pretty alarming and generated a lot of activity and requests for information to understand what was going on. You can see we'd instructed, it sounds like counsel plus 2 law firms were engaged on it. I would have been, and I think this is sort of looking at this email, I remember the time. I don't remember drafting this email, but I remember the time. I would have been trying to find out what's happening, what needs to happen, and synthesize that into digestible bullet points for people to understand the position, so that we either proceed with known risks, with knowledge of the known risks, or decide not to do things with knowledge of those risks as well. So on the when I say the legal advice, my guess is, and I'm sorry, again, I can't remember the specifics, but being told not to do it, I think will have come from a collection of the lawyers involved, which includes me as well as the external lawyers.
I take it this, if this advice does originate from others, it's not advice that you disagreed with?
Well, I mean, quite clearly, if we were reviewing it, we would be doing the claimant's work for them. As soon as we reviewed, we would see something. If it was adverse, we had a duty to disclose it. So
isn't that a reason to do something rather than not to do it in the legal system?
I'm not sure. I'm not sure. It would depend on the circumstance. And I'm thinking in this circumstance, it seems to be suggested that was acceptable. But
when you take it together with the final bullet point,
yeah.
Under audit about mitigation of risk, you say essentially before we look at these KELS, before we audit them, we should wait for the litigation to be over so that our associated disclosure duties have concluded.
Yes, I do say that.
So what you're saying, whether yourself or in synthesizing the views of others, is don't look at 14,000 new KELS because they might contain material that's adverse to our case, and in that respect we would be doing the claimant's work for them. Instead, wait until the litigation is over and our disclosure duties have passed, then conduct an operational audit.
That is what it says. Although looking at that, it wouldn't have closed off any disclosure duties as I understood them in any.
Why does it say wait until the litigation has been resolved and its associated disclosure duties concluded then?
I'm sorry, I agree, that's what it says.
But can you help us with this at all?
I'm sorry, what's the question, please?
It appears to suggest that the Post Office's suggested approach from its lawyers, either from you or communicated through you, is that we shouldn't look at documents that might contain adverse material because we might have to disclose them. Instead, let's wait until the litigation is over and our duties of disclosure have ceased to arise.
Yeah, that's what it said. I'm sorry, I'm missing your question. I'm sorry, I'm being thick.
But do you think that's appropriate?
I'm saying it's a way to mitigate the risk.
Risk of what?
Well,
Disclosing adverse documents?
My understanding, and I'm happy to be corrected, my understanding of civil litigation is the duty of disclosure in the litigation ends with the litigation. Once the litigation concluded, we didn't have a duty to disclose.
But that's why you have to discharge the duty in the litigation before it's concluded.
But that is what was that work was being undertaken. That work was being undertaken. It's a question of how far you go with it.
Thank you. That can come down.
Before it does, Mr. Beer, I just want to. I may be being wholly unduly pedantic, but there's something itching away at me. Could you put it back up again, please, that document? Just so that I've understood the timing of this, Mr. Williams, the Horizon Issues trial had taken place, but the judgment had not been given. So we're in that time period. Is that correct?
That's my understanding, sir.
Yeah, right. Now, the word disclosure may have more than one meaning in the context that I'm talking about. But in civil litigation, you give disclosure by producing a list of documents. You don't actually begin by simply sending the other side a bundle of documents, do you? You actually produce a list to notify them of what you had.
That's correct, sir. That's
right.
My understanding.
Now, in relation to these 14,000 kells, which are described in this document as new kells, had they ever been listed either in a formal list or referred to in a letter to the claimant's lawyers to notify them that they existed?
My understanding is that had happened, sir. That had happened fairly promptly upon being notified of these.
So that I'm not misunderstanding what's gone on, you are telling me that the existence of these documents had not been hidden from the claimant, but nobody had looked at them to gauge their relevance. Is that it?
Almost it, sir. Looking at this, that is correct, that they were notified. It's my understanding. I only received this document, which it wasn't referred to my Rule 9 request, so I haven't looked around this as I have some of the other issues. So this is my understanding with that caveat. So my understanding is...
So that the inquiry can satisfy itself, if it wants to, about this, what you are in effect telling me is that there will be a document in existence which shows that the solicitors acting for the claimants were notified of the existence of these 14,000 documents.
I sincerely hope so, because that is my understanding, sir.
Right. All right.
And then...
All right, well, that's fine. Thank you very much. That's your understanding, and we'll see in due course where we go from there. Thank you.
Thank you, sir. I think that document can come down now. Can we turn, please, to your view of sub-postmasters and turn up paragraphs 44 and 45 of your witness statement, please?
44 and 45, is that?
Yes. You say I've been asked to comment on some July 13 emails concerning the calendar square bug, sometimes called the Falkirk bug. These events happened over 10 years ago, and I do not now have a firm recollection of how they unfolded. As far as I recall, I was asked by Simon Baker to find out whether horizon bugs had been referred to in any previous court actions in anticipation of the publication of the Second Sight interim report. This led me to put this question to Womble, Bond, Dickinson and DAC Beechcroft, given that to the best of my knowledge they were the Post Office external lawyers most likely to have supported Post Office in any civil action. This activity made clear to me that horizon bugs had been discussed in two court cases, namely the 2007 civil case of Castleton and the criminal prosecution of Seema Misra. In the context that I was looking at them in mid-2013, however, there was no reason for me to look into this further. That was because the cases had concluded quite some time earlier, and there were no indications from those I was supplying the information to that anything further was required. So essentially, you're saying in mid-2013, you had cause to inquire about past cases, and that inquiry had led you to two cases in which horizon bugs had been discussed, Lee Castleton and Seema Misra.
Correct.
Can we look, please, at poll 0011 7614? That's E68. And turn to pages 3 and 4, please. If we just look at the end of 4, we can see it's signed off Tim. And if we go back to page 3, we can see it's an email from Tim McCormac to Paula Venables with the subject, it had to happen sooner or later, and it was sent on the 14th of October 2015. And he says, I should say this is one of a number of emails that Mr. McCormac sent directly to Miss Venables in October 15 regarding errors in Horizon. He says, this may be the last you hear from me directly. It's a last chance for you to accept what I've been telling you these last few years is true. I now have clear and unquestionable evidence of an intermittent bug in Horizon that can and does cause thousands of pounds losses to sub-postmasters. Tonight there's a branch in your network sitting on a loss of 5 figures. The money does not exist. It's as a result of several one-sided transactions being entered erroneously by the system, not the operator. I've documentation from Post Office employees acknowledging the error and that it's happened before. I have the source documentation from the sub-postmaster concerned. I have evidence of a similar event happening 2 years ago. It's also documented. I have a limited channel of contacts in the industry. 2 similar events, plus the admission by your employee that he's aware of other events, is a high percentage, and the error soon to be exposed will result in more coming to light. Most importantly, it's an error that would not be noticed by many sub-postmasters and could well be the reason for many of the GFSA cases. I have 3 options. A, this email is the first option. Appeal to your sense of decency and compassion to accept that many of the claimants in the GFSA saga are honest and decent citizens whose lives were destroyed by your organisation. B, go to the press and see what happens. Or C, await the inevitable judicial review where you will personally be exposed and perhaps leave yourself open to criminal charges. We can stop this farce now. You can wake up and realise that the people you rely on to tell you the truth about what is happening don't have the ability to do so. Option B happens on Friday. I've one former sub-postmaster who's keen to proceed with JR. Option C could happen sooner than you think. You've two options. A, ignore this email and accept the consequences. Or B, travel with me to the branch in question. See for yourself the evidence. Talk with the sub-postmaster concerned and reach your own conclusion. I want nothing out of this and will meet my own costs. If we look at the foot of page 2, one of the executive assistants to Paula Venables sends the email on to Angela van den Boogaard and others. Please see email from Tim. Can you advise what action we need to take? Further up the page. Angela van den Boogaard sends it to Mr. Davis and to you. Mark, Rod. My view is that we should ask him to share the information with us so we can make an informed decision on how to proceed. So actually taking up essentially part of option A. Agreed?
Yes.
I'd suggest this is probably best coming from Paula in the first instance. And then over the page, your reply. Thanks, Angela. I agree we should ask for the information, but recommend that we write to him in the same terms that we have every other person who said they've had evidence of flaws. Kay Linnell, Second Sight, Nick Wallace, Sandy Patel, QC, Professor Button. I've sent those letters in the past, and I'm happy to do so again. I'm also pretty sure I know about the JR he's referring to, and I've already sent a holding letter to that former postmaster acknowledging receipt of his complaint, so my name might be known to Tim already. If you agree, I'll circulate something shortly. I'll want to send it hard copy. Generally, my view is that this guy's a bluffer who keeps expecting us to march to his tune. I don't think we should do so, but instead respond with a straight bat. And Mr. Davis agrees at the top, saying, thanks, Rod, wise advice, with which I agree. By this time, October 2015, you acknowledge, we saw in your witness statement, that you were aware of suggestions that there were bugs in Horizon arising from your knowledge of the Seema Misra case and the Lee Castleton case, yes?
Correct.
The Second Sight report, the interim report, and its second report had been published by now, hadn't they?
Yes.
Why did you think Mr. McCormac was a bluffer?
So I think the bluffing is in relation to the you have options or else, the sort of threat. And he'd been a serial correspondent. I don't know where this sits in the course of that time. But my understanding is, sorry, my recollection, and it is a recollection, I am, again, so this is one of the more recently disclosed, is certainly we offered, and I think it may have been Angela van den Boogaard, met with him to try and understand the issue in the branch. And so, you know, we had already started to take steps to understand, but if he had information, which he was clearly saying he had, he should be able to share that with us so we could manage it, we could process it, understand it, and respond as appropriate. He wasn't very specific with what the issue was or where it was, so there are very limited lines of inquiry that we had internally without something more from him.
Why did you recommend that the Post Office should respond with a straight bat, i.e. avoid answering the direct questions or giving them the information they want and just bat it back to them?
No, that's not what I'm saying there at all. Saying a straight bat is whatever I think about the correspondent, we should respond to his inbound inquiry seriously and appropriately. That's what I meant by a straight bat.
You weren't referring to responding with a straight bat there as meaning when a batsman holds their bat vertically and just knocks the ball back to the person that sent it to them?
That's it. I don't know, this is the second time a straight bat to me means appropriately.
Honestly, appropriately.
Yes.
That's the sense in which you are using the expression, rather than as I've used it, I bat it straight back to them.
Yeah, no, sorry, straight bat is appropriately.
What investigation was in fact carried out?
I recall writing a letter, as I think I indicated, to Mr. McCormac. I also recognise the letters that I'd put in brackets where we'd invited other people to send. I think his was slightly different. I seem to recall it being a little bit different, where I tried to address in his email, he said there were concerns that, what did he say? People not giving the right. Sorry, maybe not here. Sorry, it's not in this one. No, sorry, it's not in this. I can't see it in there. I've lost my train of thought. Sorry. I wrote a letter to him inviting him to share it, and I think I added some extra comfort around that the material to try and give him confidence that the material would be treated properly.
Can we move on then in your dealings with Mr. McCormac?
Yep.
Poll 00119584. That's E69.
69. Yep.
If we start by looking at page 4 and 5.
So it's the date.
We're now in July of the following year.
Thank you.
And Mr. McCormac emails the Post Office, copying Paula Venables and Tim Parker in relation to an investigation into the prosecution of Seema Misra. Can you just scan that, the first part of that correspondence? And then if we go to page 5, a third paragraph, Mr. McCormac says that he finds it utterly appalling that Post Office seek to prolong the suffering of a woman, that Seema Misra, who very clearly did not commit the crime she was accused and convicted of. You have the opportunity to contact the CCRC straight away on this matter and ensure Miss Misra suffers no longer than she has to. I urge you to do so today. At the moment, I'm prepared to consider incompetence as the rational explanation behind these contemptible failings of the Post Office, to understand that Horizon is capable of producing intermittent errors that result in huge paper losses at sub-postmaster branches. Any subsequent delay will make me consider the far more serious matter of conspiracy. And then if we can go, please, to page 1.
Mm-hmm.
Foot of the page. Keep going, please. Thank you. You say, I'm not inclined to reply. Certainly we don't need to, given the tone of this and his other communications. And we've already told him we're not going to comment. Mm-hmm. And then further up the page, you provide a draft for Miss Venables' executive assistant and say, Aveen, on reflection, I'd like to go back to Mr. McCormac with a short response for no other reason than to ensure he can't allege we don't respond to issues. Mr. McCormac, Post Office Limited asked me to respond. Post Office will be happy to consider any information you may care to disclose. However, and in line with my previous reply to you, Post Office will not comment on the other matter you've raised. Why were you writing these responses back to Mr. McCormac or drafting responses back to Mr. McCormac, which all simply shut down what he was saying and didn't say, we will investigate the concerns that he raised.
And have we got anywhere in the bundle? It's referred to two bits of correspondence from one's the 4th of July 2016 and the other's 19 November, I assume is 2015. Do we have either of those?
I can certainly try and find those over lunch. Are you saying that in those we will find?
I'm not sure. I'd like to see them because they are referred to. Because I think consistent with the previous email, we said we should ask him for what he's got. And if we don't receive stuff, there's a limit to how much correspondence you can engage with a person who won't give you lines of inquiry or sufficient information to take it forward. And I think in those circumstances, and I think this was happening at the time, it's appropriate to try and draw the correspondence to an end or to a point where it can be taken forward meaningfully.
Did you think he was a mischief maker?
No, I think he was a genuinely concerned individual.
You didn't think he was making mischief?
I don't quite know what you mean by that. I think he was concerned. I mean, making mischief to me sounds like this is a bit of a giggle. I don't think nothing I saw in any of his correspondence made me think that. Quite the opposite. I think he was genuinely motivated to raise issues with us. The challenge we had is we weren't quite sure what the issue was.
You couldn't tell from Mr. McCormac. He wasn't explaining himself clearly enough to you.
He just wasn't giving us any information to take things forward. His references to an issue in a branch it's not something.
He was inviting the chief executive to come to the branch and not rely on people like you who were misinforming her.
That's true. That's a lot of people ask lots of chief executives.
Why not take that up with some other person and say, okay, we'll come to the branch and we'll look at an error unfolding before our eyes, as you, Mr. McCormac, say will happen?
As I say, my recollection is that had taken place with Angela Van Bogard, but I'm not 100% confident of that recollection. That's what my understanding is. Sorry, that's what my belief is.
Lastly on this topic, can we look at poll 304-1382? That's E28.
I'm sorry if I'm not as clear as this. I did only see these on Friday evening, so I'm not as familiar with the documents around here as I am with others in my statement.
E28.
Thank you.
Can we start, please, on page 7? If we scroll down, please. Oh, sorry, scroll up a bit. Thank you. There's an anonymous freedom of information request. Can you see that on the middle of page 7? And if we scroll up, please. Angela Van den Bogard sends that on to a range of people and says, in the light of the court action, I think legal should draft a response on this. We've provided the anonymous person options to resolve the alleged issue and cannot do much else in this public arena, and advise what they should do if they want an internal review. I think the response should be based on the fact this isn't a request for recorded information and whatever context are felt to be required. Therefore, I've attached the basic response for this amendment. And then if we go forward to page 5, please. In the middle of the page.
Yeah.
So if we can scroll, that's it. Ms. Madam Bogard says to you, this postmaster clearly thinks the answer to their problem is in this list of errors and in all likelihood is therefore not looking or does not want to look for any discrepancies in branch. I really want to try and help this postmaster, but clearly we cannot say that we will not address what they've confirmed to us, i.e. they have falsified their account. My preference would be to explain this to the postmaster, what the errors to which he refers are, and that if there were affecting his branch, we would be able to identify that. On the false accounting point, could we say something along the lines of, and then some text is inserted. And then if we go to page 3, please. And if we look at your email, that's it. 16th of November, you reply. Hi, Angela. I do not think this is a genuine request. It has all the hallmarks of Tim McCormac mischief. These Freedom of Information requests were recently cited in a blog which thanked Mr. McCormac for his work and help in relation to the Horizon system. Did you consider that Mr. McCormac was making mischief?
Well, I think at this point, sort of anonymised requests from A.N. Obedy might drift a little bit closer, but no, again, I think he was motivated to... To be clear, I don't know that this was from Mr. McCormac. I'm saying it struck me it had the hallmarks, I think, and I think reading it from reading back, trying to... the style was similar to the way he wrote, but I don't know that it was him.
Did you think generally he was making mischief?
No, I thought I'd answered that. He was genuinely motivated to pursue, I think in particular, Seema Misra's case. I think that's clear from the feeling you can see in his emails.
Thank you, that can come down. Looking back then, in your dealings with the media, with sub-postmasters, whether directly or indirectly, who were making complaints about Horizon, do you say you acted appropriately at all times?
I certainly tried to. There's a possibility I didn't. All times is quite a long time, and I think we've already seen. I sent one email that, on the banter side of things, was, maybe would not have sent or expressed differently.
Thank you.
I'd like to think I always had respect for them because they were dogged and determined.
Did you ever think, as well as being dogged and determined, they might be right?
Yes.
Did you ever express that openly? Hold on, we should all just pause. They might actually have a point here.
Well, I think we by our actions, we were doing that. The scheme sought to do that by investigating, the mediation scheme sought to do that by investigating the individual cases.
That was a genuine attempt to get to the truth, was it, the mediation scheme?
As far as I was concerned, yes.
And the setting up of the second site interim investigation before it, that was a genuine attempt to get to the truth, was it?
As far as I was aware, yes, I came after that had started. So the genesis for it, the origins for it, I'm less familiar with. But everything I saw suggested that's exactly what it was.
Can we look then at your engagement with Second Sight and the complaints that were made before it published its interim report in July 2013? So we're looking at the period here, August 2022 to July 13. And can we start, please, with your witness statement, please, at page 15, paragraph 32.
Sorry, page 50, paragraph 32. Paragraph 32. Thank you. Sorry, 15. Beg your pardon.
I should just read for context or ask you to look at context. Just cast your eye over paragraphs 29, 30 and 31. And with that background, you say in 32...
Sorry, can I just finish? Thanks. Thank you.
With that background, you say in paragraph 32, whilst these tasks gave me some awareness of the controversy surrounding Horizon, I did not get into the detail of Second Sight's work or the underlying complaints, and I was not involved in considering the merits of any of the concerns being examined by Second Sight. I just want to examine the extent of your involvement and the extent of your role at this time. Can we look, please, at poll 00143827? That's tab E80.
80 or 18?
E80.
Thank you.
Are you there?
I'm sorry?
Are you there?
Yeah, yes, I am. Sorry. I'm sorry, I thought I'd said. I beg your pardon.
It's the 1st of November 2012.
Yes, I have that.
An email from you to Mr. Flemington about Horizon immunity proposals. And you outline a proposal from the JFSA in the first 3 bullet points. If we scroll down, you say our draft response, and then you set out 3 bullet points. And so you're essentially noting the Post Office's options are do nothing to this proposed immunity, i.e. non-retribution against postmasters for engaging in the scheme. Secondly, propose a no-blame inquiry to be carried out by Second Sight, which would determine whether Horizon was fit for purpose, but would not rule on individual cases, or mediate with the JFSA. And in relation to the latter option, you say this may just add further time and cost with no guarantee of a successful outcome. Yes?
Yes.
If we scroll down, thank you, you say if we go down the inquiry route, it would determine whether Horizon is, quote, fit for purpose by reference to comparable systems. It would not rule on individual cases because of the very wider range of concern which could be submitted, e.g. inadequate training, inadequate support, user error, third-party intervention, Horizon itself. Cases will be chosen by Second Sight, JFSA, sub-postmasters, and not the Post Office. This helps neutralise any suggestion that the Post Office cherry-pick cases or that the processes are whitewashed. The Post Office can still advance its case on the investigation concerns. So just looking at that first page, it seems at this time, November 2012, so within 3 or 4 months of you joining the company, you were engaged in considering how sub-postmasters' concerns would be addressed by or interact with an investigation by Second Sight, weren't you?
Yes, I was. I actually, looking at my statement, I'm sorry, what I think I'm saying in paragraph 32 is I wasn't looking at the detail of the individual complaints. So I'm sorry if that's given the wrong impression.
Why were you conscious of suggestions that the Post Office would cherry-pick cases or whitewash cases considered by Second Sight?
Well, to get a conclusion, you need something. So what my understanding was, they were trying to. The Second Sight had been instructed to get to the bottom, to see whether issues with Horizon could have been the source of unexplained shortfalls in branch accounts. If Post Office leads with its own cases and only its own cases, it's marking its own homework. It's open to challenge being, biased selectively in favour of their own, and hence the exercise was probably unlikely to satisfy the counterparty.
So it would be fair to say, looking at your involvement at this stage, you're addressing process or structural issues rather than an individual case?
I think so, yes.
Yes?
Yes,
okay, we can take that down. Can we look, please, to poll 0018 6090? That's tab E100.
100. I have that, thank you.
We're now in spring 2013. And can you see that at the foot of the page, we scroll down, keep going. The Mr. Swepson, who's a program planner in the IT Separation Program Office, if we scroll down a little further, sends you some spot reviews. Just summarise for us what a spot review was.
My understanding of it, the spot review was Second Sight's work had identified specific instances of, I guess, branch issues at the widest level that had been put to them by the postmasters that they wanted to deep dive. Those issues were sort of crystallized into an issue, with each issue being named a spot review. So I think two are referenced in there. So spot review was an attempt, forgive me, I'm fluffing my lines. Spot review was an attempt to analyse in detail a specific allegation raised to Second Sight through this interim early phase, the first phase of their work.
Thank you. And if we scroll up, that having been sent to you by Mr. Swepson, if we just look at the email, you send it on to Gavin Matthews and Andrew Parsons. Yes?
Yes.
You say, I confirm our meeting this Wednesday is at Old Street. I attach the spot reviews we've received and our current draft responses. We'll discuss the responses at the meeting with a view to producing a standalone document which sets out our definitive position on the issue raised in the spot review. The final response may enter the public domain. So we need to ensure it's robust, defensible, and properly protects and advances, or advances, Post Office Limited's case. I look forward to, I suspect that's been should mean briefing you on Wednesday.
Yes. I wondered if it was either briefing or meeting. I'm not sure, but it's a typo for sure.
You told us in your witness statement that you were not involved in considering the merits of any of the cases being examined by Second Sight, and this seems to have you going to a meeting to discuss a draft response.
Yeah, I don't believe I attended that meeting. I don't recall doing it.
But why were you involved, or why were you to be involved in the formulation of the Post Office's responses to spot reviews?
So part of my role, I was quite often the point man, the conduit between external advisors to a project team. In this case, Bond Dickinson were supporting Post Office's review of the spot reviews, and I think the program lead for the Second Sight engagement. I think these are footnoted somewhere in my statement. The project lead was a guy called Simon Baker. I think he had asked for two things. He thought one was to strengthen the language, the form, the content of the spot reviews to better advance Post Office's response to the issues.
To put it as robustly as was possible, is that right?
Quite possibly. I can't remember if that's the words used, but it was of that tenor, yes. And then he also asked, I think, for support from some lawyers on that. Because, and then thirdly, I think he also asked if I could arrange a meeting at their offices, because finding a meeting room was always quite difficult. I have to say I don't particularly recall this, but I managed to refresh myself from my documents. I think ultimately the meeting was held at 148 Old Street, which was Post Office's office, which is why I think I was able to meet Gavin and Andy when they came. But as I say, I don't recall actually attending the meeting.
Was a defensive approach taken to Post Office's response to the spot reviews?
I suppose you could say offensive. You could also say it was an offensive one. It was a proactive one. They were trying to positively advance their response. You could say it either way. Both are, I think, fair interpretation. It was certainly trying to put their position, our position, as firmly as possible.
To what extent did that undermine the purpose of the Second Sight investigations?
I don't think it did, because Second Sight would review it and consider it and comment as appropriate. But
it wasn't meant to be a litigious or adversarial process, was it?
No, but also I don't think articulating things in a clear and representative manner is necessarily adversarial. I mean, you might like what's been written, but it doesn't mean it's not there for consideration.
Were instructions given to you to take an open and transparent approach with Second Sight, or to take a robust one which properly advanced a case on behalf of the Post Office?
I don't actually recall any instruction either way on that. It was provide information to them that they asked for. At this stage, it certainly was that.
Was there no overarching strategy in the Post Office's response to the initial Second Sight investigation?
I'm not aware of one. Or I don't recall one today, certainly. I don't recall being aware of one at the time either.
You don't remember instructions to the effect that this process has been set up as an alternative to litigation. We should not adopt an adversarial approach in it, a litigious approach, one in which we are lawyered up. We should try and be as open as possible to let the truth filter out.
I'm sorry, there's a lot in there. So what's the question, sorry?
You don't remember any instructions for the purposes of the initial Second Sight review to you or to lawyers involved in the Second Sight initial review, which said that we should adopt an open and transparent approach? Sorry, yes.
I'm sorry, yeah. I don't recall an instruction like that. On the litigation point, I think I became aware that these had recently been similar cases had recently been the subject of litigation, and there was a concern that that was always in the background. So I wouldn't want to say that there wasn't a concern of litigation in there, which is why, and here you can see I've said, look, they need to be defensible and properly protect Post Office's position. I don't know that that's inconsistent with putting forward information in an open or transparent manner. I think it's just how it's presented.
Can we move on? Poll 307 4005. That's tab E43.
43. I have it. Thank you.
We're now in November 2013. And we can see from this page that you writing to Mr. Parsons saying you attach your markup of the Post Office's response to the Castleton CQ. Can you remind us of what a CQ was?
I think that's a case questionnaire.
And can you remember the functional purpose of a CQ?
I hope so. It was the applicant to the schemes. It was a form in which an applicant to the mediation scheme would articulate their concerns, what they wanted investigated, and why, I believe. Sort of the inbound complaint, as it were.
Anyway, you attached amendments to a proposed reply to the case questionnaire. And in the third paragraph, you say, taking a step back, Mr. Castleton seems to be relitigating his High Court case. I'm going to look at the judgment over my sandwich, but a very quick glance shows that even the £100.20 scratch card issue was considered. I appreciate that we can't just behind that. He'll say he didn't have the resources to take on the big boy. But I do think we can set out a stall where we portray him as someone who wants £5.2 million after providing inadequate services for all of 9 months. So this was you amending, tweaking the Post Office's response in the initial second site review process.
Yes.
You told us in your witness statement that you weren't involved in considering the merits of individual cases.
I think that's because where I said that first bit, it was in relation to second site's work up to the interim report. This is produced through the mediation scheme, so where I did look at the detail of some cases, but certainly not all of them.
So after July 13, you took a different role, is that right?
After July 13, when the mediation scheme started, I did start looking at some cases in varying depths of detail.
Why was your reaction to Mr. Castleton's CQ to set out a stall rather than investigate the issues that were raised?
In this case, and it literally was, I think, this sole case, I was aware that Mr. Castleton's complaints about branch accounting had been the subject of a high court proceedings and indeed trial and judgment, which the judgment of which underpinned a lot of Post Office's operating practices with respect to, as far as I could tell, with respect to postmasters up until the group litigation.
That's interesting. Tell us to what extent the Lee Castleton judgment underpinned a lot of the Post Office's operating practices until the next judgment 12 years later.
It was a High Court judgment that confirmed an agent's liability to the principal for accounting, And it also made findings that Horizon had been working, quite specifically though, in that case, in that branch.
How did that second point underpin the Post Office's approach to its operating practices for the following 12 years?
Well, I think it was a strand, but certainly not the only one that gave them confidence in the reliability of the system.
Was it reviewed or referred to a lot within the legal team then?
Yes, it would have been. It was as far as I was aware at that time, and I think that certainly from my time, it was the only High Court judgment on this issue, or certainly the most I'll rephrase that. It was the most recent one. I definitely know that.
And was its importance elevated or emphasised then within Post Office's legal team?
Well, certainly to me it was, yes. Yeah.
And who did that to you? Who said that to you? Or are you saying that you read the judgment and formed that view yourself?
I certainly think it's the latter, but I would have said it was the latter. Yeah, I would have said it's something I formed.
And so what did you take from it? I think you said two things there. Firstly, it confirmed the agent point. Yes?
Yes. I'm trying to think what else I take from it. I haven't read the judgment for a while, but so that was one of them. One bit was an agent's liability to principle, and the second point was that when they looked at the complaints, and this is what I refer to here, the specific complaints that had been raised had been forensically interrogated in the High Court proceedings to the point that a judge was able to say Horizon was working, or the judge felt able to say that.
You say here that you can't hide behind the judgment.
Can you remind me where I say that, sorry?
Third paragraph, taking a step back, Castleton seems to be relitigating his High Court case. Mm-hmm. I appreciate we can't just hide behind that.
Yeah. No, it's as I'm saying, you can't just say, hey, you litigated and go. But I thought it was fair to make comments that some of the issues he had raised had been raised and adjudicated on before. I think what I'm saying there, again, it's a little while, I think what I'm saying there is you can't just be dismissive. You had your day in court, go. But also, I think it's appropriate to recognise the judgment and the proceedings that had taken place.
Thank you, that can come down. After you became involved more extensively in the second site work, did you continue in your role as point man for media relations within the legal team?
Yes, I would think so.
Can we look at poll 00145120, please? That's E82. And can we start by looking at the foot of page 1 and onto page 2, please? We'll see an email from you, if we just scroll up, thank you, of the 3rd of July 2013. So this is 4 or 5 days before the publication of the second site interim report. And you are emailing Susan Barty, who's a partner, I think, at Cameron McKenna, yes?
Correct.
And you say, in relation to the second site interim report, we expect to receive the second site interim report late Thursday, early Friday. I'll forward it to you as soon as it's to hand so you can review it for factual accuracy, as requested by the chairman. And as requested by the chairman, any possible defamation issues, we want as quick a turnaround as possible. Why did the Post Office engage Cameron McKenna to review the second site report for defamation issues?
I think there was a concern. I was working on sort of direction
From the chairman?
Well, actually, I was getting it sort of second-hand, I think, from the General Counsel.
But you understood it came from the chairman?
I certainly understood it came from the chairman, that there was a concern that they wanted to know that the reporting would be accurate. Sorry, the report would be accurate.
Well, that's a bit different, because you say you can review it for factual accuracy and any possible defamation issues.
Yes.
Was the Post Office considering suing Second Sight for defamation?
It depends what I wasn't aware of that instruction.
Right from the top?
I don't know exactly what from the top was. What I recall was being asked to get a media lawyer to look at it because, and I think, defamation was used, so clearly it was used. But I wouldn't go so far as to say because they're thinking of suing. I think we're being asked to look to see what grounds there may or may not be for something like that.
Why would the Post Office be looking at what grounds there would be to bring a defamation claim against Second Sight?
So I think it's reputation management first and foremost. Are untruths going to be said that may damage Post Office? I'm pretty sure, because I did look around this a little bit, I'm pretty sure we gave some advice pretty quickly explaining the challenges that a corporate entity has in pursuing defamation actions, and in particular the need to prove demonstrable loss. But I think that the shorthand was, are untruths going to be said which will cause us harm?
Again, was that part of the open and transparent approach that the Post Office was taking towards Second Sight's work?
I don't think so, no.
So it's 1 o'clock nearly. Might we break now until 2 p.m, please?
Yes, of course.
We're about to change topic.
Fine, that's fine.
Thank you. Good afternoon, sir. Can you see and hear us?
Yes, thank you.
Good afternoon, Mr. Williams. Can we go back to an issue that we addressed this morning, which was your advice on communications with Tim McCormac, and you asked whether it would be possible to see a letter that you wrote. I think I've tracked that down.
I think.
It's poll 0011-8066. Can you see this is a final version of a letter that was sent to Mr. McCormac? At the foot of the page, we'll see that it was sent by you. And at the top of the page, we'll see it's the 19th of November 2015. And if you just quickly scan the paragraphs to see whether it's the letter to which you were referring.
I think it is, thank you.
It is the letter. And so it was the point that you were making that in this letter, by this letter, you had asked Mr. McCormac to provide you with evidence.
Yes.
Thank you very much. So in relation to some questions that you asked Mr. Williams, that can come down, that you asked Mr. Williams earlier about the post-trial pre-judgment exchange of correspondence over the 14,000 new Kells. There is some material which touches upon that. I'll address that, if I may, tomorrow morning with Mr. Williams, so that we've got the complete set of correspondence on the system.
Thank you.
Can we turn to the provision, therefore, Mr. Williams, of material to second sight? Can we turn up page 14 of your witness statement, paragraph 30, please? And can you see in paragraph 30, you say second sight had been appointed before you joined the Post Office and you didn't have any direct knowledge of the process or how the scope of its original retainer was determined. And then 3 or 4 lines on, you say, I felt I needed to raise the risks around disclosing legally privileged documents to a third party without putting a clear framework in place to govern their use.
Yeah.
And then if we go to paragraph 34 on page 16, please. You say you review remembering a number of drafts of spot reviews to see what they look like, sharing thoughts with Womble Dickinson. And then a couple of lines on, I recall that the Post Office sought to organise the preparation and drafting of the spot reviews in a way that would maximise the potential for the Post Office to claim legal professional privilege over them and any exchanges with Fujitsu relating to them as they were being developed. Was that essentially a strategy that would apply in ordinary litigation?
I would think so. When it's contemplated, you're usually keen to understand what's an issue before, so that you can take informed advice on it before proceeding to take your actions.
And were you comfortable in cross-applying that approach to the second sight initial investigation?
I think there are 2 bits there. Part of it was also so that the company could obtain advice on what was being revealed through the investigations. So I think that the privilege and issue wasn't just in connection with, say, contemplated litigation, but also so that advice on what it may mean for Post Office's legal position could be obtained as material was identified.
Was
or
any...
created.
I'm sorry.
Beg
Was
your
any consideration given to the fact that you were not in litigation at this time, but you were in a sort of quasi-mediation process?
My recollection is that the prospect of litigation was sort of always sitting there. Looking at it today, I'm not sure whether it would be properly contemplated for the purposes of litigation privilege, but at the time it felt like a claim was always around the corner.
And that can come down. Was any consideration given to the fact that your company was government-owned, and in many of the functions it discharges them, or they are functions of a public nature?
That was a consideration that came up a lot, but it was a public body. Mm-hmm.
You called it a public body there. Was that a factor that was brought consciously into account in the course of either the first part of Second Sight's activities or when you entered the mediation scheme proper?
I don't recall it. I'm thinking it's more. Sorry, let me. Sorry, could you have another go at the question? I think I know where you're at, but I'd like to make sure I understand the question.
Was any consideration given to the fact that your company was government-owned and many of its functions were those of a public nature? You called it a public body. In either the initial activities of Second Sight or when you entered the mediation proper?
Yes, it was. Now, I'm sorry, and thank you for. I appreciate that. I think they're a little bit. I remember it being an issue largely because of questions around whether, from insofar as my role was concerned, whether Post Office's actions may be amenable to judicial review was certainly part of that consideration. And I think there was also consideration that Post Office is amenable is open to Freedom of Information Act requests as effectively a designated body fit for that act.
Both of those answers, Mr. Williams, are essentially technical legal answers as to the status of the Post Office and the application of either public law or the Freedom of Information Act to it. My question was, in the context of either the initial work by Second Sight or in the mediation proper, was consideration given to your status as a public body, as you've described it, in terms of how should we approach these things?
I don't think so. I think the not terribly far removed from that maybe was the concern that Post Office is in every community throughout the length of the breadth of the country. That was Post Office's status in those communities was, I think, part of it. But and we were also, aware of, very considerable stakeholder interest from members of Parliament who were considered. I think they're quite often referred to as a stakeholder group. But I don't recall anything other than that, but that may be because I just wasn't in my bailiwick.
It's sometimes said that public authorities, public bodies, or organisations who discharge functions of a public nature should operate by different standards in litigation or quasi-litigation, like a mediation. Was that something that was ever discussed within the legal team, so far as you're aware?
I don't recall that, no.
Was it ever discussed between you as the lawyers and executives as the client?
I don't recall that.
I hold on, we're a public body here. Some might say that we've got different duties and standards to adhere to and apply. We're not just another big corporation who's free to litigate in any manner we choose?
Not in those terms, but there was the sense that, Post Office. I do think there was a sense the Post Office, because we were in communities, length and breadth of the nation, it was important to be doing the right thing. I think that's probably the way to describe it. I think there was a concern for that to be done. I don't recall it in the sort of construct of the public body that you've been describing.
I think it's fair to say in the 130 odd pages of your witness statement, we don't see the considerations that I've just raised reflected. That's right, isn't it?
That's correct, yes.
And in any of the documents, I don't think we see those considerations reflected, do we? Certainly the ones you've seen.
No, we don't. I don't think so, no.
Was that a concept with which you were familiar at the time? Public authorities may have to behave differently when they come into contact with the law than private companies.
No, that's not a concept I'm familiar with, I'm sorry.
Would it be fair to say that in your legal advice and any discussions you had with clients, you regarded the Post Office as any other litigant? It could be a big city corporation.
No. I don't think we could act in the way Big Oil would act.
So I missed that word, big.
Sorry, Big Oil, for instance, like a large petrochemical company. No, I think there was.
Why not?
Because there was a sense that. I think Post Office was concerned about its image. It's in communities. It's part of the fabric of society, and as a consequence, it couldn't be a plough on, be damned.
Okay, we'll move on. Can we turn to page 17 of your witness statement and paragraph 36? Page 17, paragraph 36. You say the inquiry has asked me to comment on a draft email addressed to John Scott, the Post Office Head of Security, and Rob King, the Post Office Senior Security Manager, and that's Mr. Scott's deputy, which was sent to me and Simon Baker on the 13th of May 2013 by Dave Posnett, an accredited financial investigator. It contains a series of bullet points, updates on the spot review process. It appears from the email that I'd asked for draft responses to be sent to me for forward transmission to Messrs. Scott and King. I believe I requested this for two reasons. First, part of my role was sometimes to review and or distill information provided by one part of the business comprehensively for other parts of the business, so there was a consistent joined-up position. Second, if the emails contained legal advice or concerned matters on which legal advice would be required, then the Post Office would be better placed to claim legal professional privilege over the material if it had been sent to or received by a legal advisor. Do you agree that Post Office could not claim privilege over communications simply because they were sent by or to a lawyer?
Yes. You cannot claim privilege just because it's sent to a lawyer.
Were you, by adopting this approach, routing emails like this through you, seeking to protect the communications in that way by making a claim of privilege available to you?
Yes, if the claim was available. If the communication was for the purposes of obtaining advice, or advice sort of flowed from it, it raised issue. It's my recollection at this time was information was being created and generated that some of it was new to Post Office, and it was certainly newly created, for instance, the spot reviews. And it wanted, I think, to understand what that was, take advice as appropriate on it, before it entered the public domain, where its ability to address the information would be harder to manage.
Can we look, please, at poll 0014-2323? I'm afraid I haven't got the tab number for that.
We'll have it go on the screen, that's fine.
Poll 0014-2323, thank you. It's a one-page email from Mr. Scott to, amongst others, you. You can see the distribution list at the top. Okay. And the subject is the protection of commercially sensitive and or legally privileged information. And Mr. Scott says a review has been conducted in respect of commercially sensitive and or legally privileged information, in particular the management of exchange of information subject to the second site review. While most information within this group will be legally privileged, nonetheless, if the information was to inadvertently be sent to the wrong email address or intercepted innocently or otherwise, once out in the public domain, it will be hard to control. Having agreed with Susan Crichton with immediate effect, all information should, where possible, be placed onto a document, and access is through a password protocol. The procedure is easy to use and only takes a matter of seconds. And then there's some administrative details, and then additionally, commercially sensitive and or legally privileged information should not be copied or pasted onto unprotected email text to make it more easily readable on a BlackBerry. Why was a review conducted in mid-2013 of the management of an exchange of information with Second Sight?
I'm sorry? I'm sorry, it was a bit too quick. I didn't.
Yes. Why was a review conducted in mid-2013 into the management of an exchange of information with Second Sight?
I don't know what triggered that.
Can you recall?
Sorry, could I see the date of this?
Yeah, it's July.
Oh, sorry. Sorry. Now I see the date. I imagine that this, I don't know about the review, but there was certainly an issue with potential shredding reported shredding or suggestion to shred, however you want to describe it, of documents, I think in July, around this time. I might need some help with the date, but it certainly feels contemporaneous to this.
Do you think this review into the management and exchange of information subject to the Second Sight review was therefore triggered by the allegation that some minutes of a meeting either had been shredded or were ordered to be shredded? Sorry,
I think there are two parts there. I'm not aware of a review in the sense of we had quite a few sort of quite formal reviews. I'm not aware of including say of the past prosecutions that was about to commence at this time. So I'm not quite sure about that. But I think that I suspect the catalyst for this will have been what you described. I'm not sure about the format of it. Does that make sense?
Do you know who conducted the review?
Well, that's what I say. I'm not really familiar with the concept of a review here.
Mr. Scott was somebody whose department was under scrutiny in the course of the review, wasn't it? The Second Sight review.
Yes. I think security files were being provided. Yes, I think that's correct. Yeah.
i.e. the way that investigators had conducted themselves, was something that some complainants had raised?
I don't know whether I was aware of that at the time, but I think that's correct, yes.
Do you know whether Mr. Scott conducted the review of commercially sensitive and legally privileged information?
As I say, I'm not familiar with the review, so I don't know who may or may not have carried it out.
Can I turn then to the second site interim report of the 8th of July 2013? I think it's right, you know, that report, sorry, that can come down from the screen, referred to 3 bugs in Horizon: the receipts and payments mismatch bug, the suspense account bug, and the calendar square, sometimes called Falkirk bug.
Yes.
And you know, I think, that Simon Clarke's advice of the 15th of July was written in response to, amongst other things, that interim report.
Can I say, I'm afraid I get Mr. Clarke's advices confused. Can I be taken to the 15th?
Yeah, we can look at the first advice if you want to. It's the 15th of July advice, poll 3 zeros 4 zeros. That's B65 if you want to look at it.
Pardon. 65, was that?
So we've got the second site interim report picking up the 3 bugs
Correct.
of the 8th of July 2013. And then this, 7 days later.
Yes.
We can see, if we go to the last page, which is page 14, the date of the...
Thank you.
Just let it come up on the screen, thank you. The date of Mr. Clarke's advice. If we go back to page 1, it's an advice on the use of expert evidence relating to the integrity of the Fujitsu Services Horizon system. The inquiry is very familiar with this, so I'm not going to go through it at length, instead take you to some parts of it. Can we go to page 10, please? And paragraph 28. Mr. Clarke says, in considering this report, that's the second site report, I only take account of those matters indicating a prior knowledge of Horizon issues. And then he says the following paragraphs appear relevant, and then he cuts in extracts from the second site report. At his, or at their 6.5, the first defect, that's the receipts and payments mismatch bug. And then at 6.6, the second defect, that's the local suspense account bug. He doesn't, in fact, mention Mr. Clarke here, the fact that second site had been told about and picked up the calendar square and Falkirk bug. And then he continues at 29. On Thursday, the 27th of June, Martin Smith of Cartwright King was telephoned by the Post Office. There then ensued a number of conversations between Martin Smith and senior Post Office executives. The import of what Martin Smith was being told may be summarised thus. He was informed by Post Office that a report commissioned by Second Sight by Post Office and as yet unpublished indicated that Horizon may not be bug-free. There was much speculation as to the content of the Second Sight report. It appeared to the Post Office that some within the organisation had been aware of bugs affecting up to 30 offices, including some Crown Office branches. Jarnail Singh, head of criminal litigation, had been unaware and did not know how long Post Office had known of the existence of the bugs, nor indeed who at the Post Office had known. And so we've got Mr. Clarke recording here that Mr. Singh, on being told of the possible conclusions of Second Sight as to bugs, said that he had been unaware and didn't know for how long the Post Office had known of the existence of the bugs, nor indeed was he aware who at the Post Office had known. Yes?
That's what it says, yes, I can see that.
Keeping this in mind, in paragraph 46 of your witness statement, I'm not going to ask for it to be turned up at the moment, you tell us that in relation to these 3 bugs, that prior to publication of the interim report, your role was to collate and distill information for the use of others, considering the Post Office's response to the interim report.
Yes.
Yes?
Yes.
Can you please help us? Before the second site report, had Mr. Singh ever informed you that in fact he had been the prosecutor in the case against Seema Misra?
I don't know about that particular status, but I remember seeing an email exchange where, when I was asked to, I think we referred to it this morning, I was asked to see if I contacted Bond Dickinson and GAC Beechcroft to see if bugs had been referred to in any cases. And I saw that John L. seemed to have known about that, the Misra case and that, but I don't recall it.
I'm asking him specifically about whether before the second site report, Mr. Singh had ever told you that he was in fact the prosecutor in the case of Seema Misra.
I don't recall that, no.
Did he, before the second site report, tell you that, having been the prosecutor in the Seema Misra case, that he had been told about the Calendar Square or Falkirk bug?
I don't recall that.
Back in 2010?
Yeah, I don't recall that being said, no.
That he had been told about a locking issue in Horizon that had caused transactions to be lost?
I don't recall that, no.
Did he tell you before or at this time that he had been told back in 2010 that there were some 200,000 system faults recorded in relation to Horizon?
I don't recall that, no.
Did he tell you that part of the work that Fujitsu had undertaken in the prosecution of Seema Misra was to provide an estimate of what would be involved in providing the defence with all change requests made at the Horizon counter, but that the Post Office had decided not to go through with that work?
I'm not aware of that, no.
Did Mr. Singh tell you at this time or before this time that both he and Rob Wilson, the then head of criminal law, had been personally informed about the receipts and payments mismatch bug back in 2010?
I don't recall that, no.
That they had been engaged in discussions and conferences as to whether or not to disclose that information about the payments and mismatch bug to Seema Misra's defence team?
No, I don't recall that.
And that a decision had been made not to give disclosure?
I'm not aware of that, no.
If we can turn up at paragraph 46 of your witness statement, please. Paragraph 46. At the foot of page 23. You say you've been asked to comment by us on your knowledge in mid-2013 of the local suspense bug. I've been referred to some emails mentioning it from around the same time as those relating to the Calendar Square bug. I believe the Post Office brought the local suspense bug along with the receipts payments mismatch bug to Second Sight's attention the context over the page in which I came to deal with these bugs was the same as I've described above, and my role was again to collate and distill information. Was there any sense at this time, mid-2013, around the time of the publication of the Second Sight report, that the Post Office was essentially saying this information about the 3 bugs is newly acquired information by Post Office?
I'm pausing to answer because it seemed to be new to some people within POL, hence the request to try and find the information, package it up and present it to people. But by the same token, we seem to be able to get answers to it.
That can come down from the screen, thank you. Are you saying that when the interim report came out and these 3 bugs were mentioned, that was news to some people within Post Office, but not to everyone?
It was certainly news to some people, and what I don't know is having been able to find people within the business with some understanding of it. I don't think I ever found out whether they'd started that inquiry at the same time I had or had prior knowledge of it. So it was certainly new to some people.
Did you seek to ascertain when the Post Office had first become aware of those 3 bugs?
I think that came out with some of the. I didn't proactively seek to find that out. I just tried to find out what we knew, and through that, it was clear that. I think somewhere in there's a date that says we've known about this since. I did a timeline where I think it was amended to include a date, but that wasn't a line of inquiry. It was more that a consequence of my request for.
Wasn't that line of inquiry an important one to ascertain when the Post Office had first become aware of those 3 bugs?
Yeah, probably. Yeah, I would say.
Would you go as far as definitely?
Yes.
I mean, if I give you an example, wasn't that information critical to determining which prosecutions might be tainted if full disclosure of the existence of those bugs had not been given?
I have to say, questions like that I wasn't aware of at that time. I had no idea what the impact on prosecutions might have been when I was being asked to find information about the bugs.
Wasn't that information that was of prime relevance to which, if any, sub-postmasters' contracts may have been wrongly terminated?
Possibly. It depends on the basis for termination, I think.
Wasn't that information, i.e. when did we in Post Office know about the existence of these 3 bugs, relevant to the issue of which, if any, of Mr. Jenkins' evidence may have been tainted?
That's a criminal law matter, so I can't give a view on that, I'm afraid.
To your knowledge, did anyone seek to ascertain which departments or which individuals within such departments knew about the existence of those 3 bugs?
I'm not aware of that, no.
Do you know why not?
I'm sorry, I don't.
We've got this report that says there are these 3 bugs. When did we, Post Office, first know about them? And how does that affect the proceedings that we've brought against people, whether civil or criminal? And how does it affect contracts that have been terminated?
Well, I think there are 2 parts to that question. So the first bit is when did we first know about that? Well, that seemed to be coming out from the request for information about the bugs. The use of that is a segment. Was it important to find out? Well, I think it was being found out from what I could see. Somebody said, well, we first knew about it on this date, we told Fujitsu about it on that date. that's with respect to one of the two bugs. I can't remember whether we did it for both. What its impact was was being shared with certainly the criminal lawyers at the time, who would advise on what the impact of that for prosecutions would be.
Did you get any sense, working as you did within the Post Office at a relatively senior level here, of the Post Office reacting as though Second Sight's report was revelatory of matters that it did not know about?
Yes, I did have that impression.
At this time, mid-2013, did you know that there is evidence that the Post Office first knew about the Calendar Square Falkirk bug way back in 2006?
I think if it's Falkirk Calendar Square, I think that seemed to have been a known issue within the company.
We've got evidence that Fujitsu had told the Post Office about the receipts and payments mismatch bug in 2010. And we've got evidence that the Post Office had known about the existence of the suspense account bug in 2012. In fact, knowing about it before Fujitsu did. Did that information come to the surface at the time of the publication of the Second Sight report?
The only thing I can remember coming to the surface was I think the 2012 one, when we first knew it. I don't recall, I'm sorry.
Did you gain any sense at this time, mid-2013, that the Post Office was pretending that the Second Sight report was revelatory of matters that it didn't know about, when in fact that simply wasn't the case?
Well, I don't know if I can speak for the whole company, but there was, I didn't get the sense of anybody pretending anything.
Can we
I didn't see any artifice around me, if that helps.
Can we turn to actions arising from the Second Sight interim report? Can we turn up, please, poll 406799? I think that's B79.
Thank you. Yes.
And if you go to the last page, please.
Mm-hmm.
You'll see that this is Mr. Clark's further advice of the 2nd of August 2013. Mm-hmm. And if we go to page 1, please. Mm-hmm. And paragraph 2. In paragraph 1, he says, on the 3rd of July, I attended the Post Office in conference at head office. So this is an advice written a month later, where he's summarising or reflecting back what had happened at a conference on the 3rd of July. And in paragraph 2, he says, one of the topics considered by the conference was that of disclosure. I advised there ought to be a single central hub, the function of which was to act as the primary repository for all Horizon-related issues. It would collate from all sources into one location all Horizon-related defects, bugs, complaints, queries, and Fujitsu remedies, thereby providing a future expert witness and those charged with disclosure duties with recourse to a single information point where all Horizon issues could be identified and considered. The rationale behind the advice derived from the need to protect the Post Office from the current situation repeating itself in the future. What did you understand the current situation to be referring to, the risk of which there was a repetition?
I think bugs surfacing, which those who ought to be aware of them weren't.
Can we turn, please, with that context in mind, to poll 00191968? B57.
Sorry, this is between bundles. I beg your pardon. Yes.
You'll see it's your email of the 12th of July to Mr. Scott, copied to others, including Ms. Crichton, Mr. Flemington and Mr. Singh, with the subject of regular call re-horizon issues. So I think putting the chronology together, this is after the conference that we've seen summarised by Mr. Clark of the 3rd of July 2013. Yes?
Yes.
And you say, following the call earlier today, I set out a draft email to go to the various heads of regarding a weekly call during which any horizon-related issues can be raised with the wider business. You ask for comments, and you say someone from Bond Dickinson should participate in the calls we have with Cartwright King, so our criminal lawyers and civil law lawyers are aware of what the other's doing. This will be especially important as further spot reviews come in, which may raise issues relevant to the prosecutions Cartwright King are pursuing. And then the text of the email. We are instigating a regular conference call during which issues with Horizon, user experience and training support can be shared across and known to the various business units which use and rely on the system. This will aim to ensure that all Horizon issues are brought to the attention of user groups who might not be aware of the issues, but whose use of Horizon may be affected by them. To make sure we've all user groups covered, we need to have a representative from each of the following teams, and then you set them out, and you ask for representatives to be put up. Yes?
Yes.
Can we go to paragraph 69 of your witness statement, please, which is on page 35.
Thank you. Yes.
You say in the third line, so I'll just wait for the screen to catch up, page 35, paragraph 69. You say in the third line, my recollection is that the purpose behind the calls was for issues with Horizon to be raised and recorded so that there would be visibility of them across the business and to avoid operating in silos. I also recall that Post Office's external criminal lawyers were keen to have these calls so as to create a record of Horizon issues which they could consider for disclosure in prosecutions.
Yes.
Thank you. But would you, that can come down, thank you. Would you accept that the advice that Mr. Clark had given that we've seen about the creation of a central repository reflected no more and no less than a duty that the Post Office had always been subject to retain and record information that was potentially relevant to its prosecutorial function?
I don't think I can make that jump on whether it's part of the prosecutor's duties or had not been. It certainly seemed to be a pragmatic, in fact, necessary development to take matters forward.
So did you see it as a development caused by the circumstances that the Post Office had got itself into, rather than there ought always to have been a process by which information or evidence that was potentially relevant to prosecutions was routinely collated, recorded and made available?
Sorry, I'm struggling to hear. Sorry. Sorry, there are two parts to that. Again, I had the first, but I lost the second. I'm sorry.
Were you seeing this as a development that arose because of the circumstances that the Post Office found itself in?
Yes.
Rather than something that always ought to have been in existence, namely a process by which information and evidence potentially relevant to prosecutions was routinely collated, recorded and made available to prosecutors?
Yeah, I can't comment on the second part of it. I don't know whether it ought to have been there or not, but it certainly seemed to be something that needed to be put in place now.
did it seem to you, even as somebody who was not expert in criminal law, surprising that it was only in 2013 that steps were taken to ensure that material was not held in silos?
Yes.
In relation to this proposed hub or forum, were technical specialists from the Post Office and Fujitsu invited to attend and contribute to them?
I certainly think from the Post Office side there was. I don't recall about Fujitsu.
We've seen the cast list, or the departmental cast list that was previously set out. I don't think there's anyone from Fujitsu on that, is there?
No, I don't think. I don't think so. No.
And why was that?
I don't know. I may have put that together quickly, and I had a placeholder. I don't know why it's not there. I don't think it was. Sitting here today, I don't think it was a deliberate omission. Put it that way.
You don't think it was?
I don't think it was a deliberate omission.
Well, if the intention or the purpose of the hub was to avoid operating in silos, why weren't Fujitsu invited to attend?
I'd say when I put that together, I was still trying to get my head around how things worked, so I didn't know who the right people were, which is why I had a placeholder in the draft for other. I didn't know whether we had the internal capacity to deal with it ourselves. I think I've subsequently come to know we didn't have that internal capacity. When I wrote that email, I wouldn't have known either way, I don't think.
Going back then to Mr. Clark's first advice, we skip forward to his second to see something that he had written about an event that had occurred in July. In paragraph 80 of your witness statement,
80,
80, yeah,
thank you,
which is on page 40, you say, the inquiry has invited me to comment on two pieces of advice. I've not taken you to the 19th of July one yet. And then about 5 lines in, you say, I do recall that the 15th of July 2013 advice raised Cartwright-King's serious concerns about about evidence which Gareth Jenkins had provided in prosecutions. I believe that those concerns would have been taken forward as appropriate by the Post Office's criminal lawyers, and recall there being a general consensus following this advice that Gareth Jenkins could no longer be used as a witness in criminal proceedings. Were you personally concerned by the advice given in relation to Mr. Jenkins and its potential impact on the safety of historic prosecutions?
Again, there's sort of two parts to that question. Was I concerned? I saw there was concern from the criminal lawyers advising Post Office, so I assumed that wasn't. I assumed that was well-founded. I should say it was a positive thing. Quite how it would impact past prosecutions isn't something I could comment on.
Did you form a view that some past convictions that had been founded upon Mr. Jenkins' evidence were unsafe, or at least were potentially unsafe?
I've never been able to form a view on the safety of convictions, I'm sorry.
So you didn't?
I didn't know either way. It's what I could see is that the right people seem to have raised it and would know what to do with it. And they seem exercised by it. That is my recollection. But quite what the impacts of it would be, I had no frame of reference to measure it or judge it by.
Can we please go back to Mr. Clark's advice, poll 3 zeros 4 zeros. And can we turn up page 11? And look under discussion.
Which tab is this one at, sir? Is it 76?
B65.
I beg your pardon, please. So it's between... Thank you.
But it's on the screen.
Yeah, thank you.
If you look at paragraphs 33 to 35,
Yes.
did you form a view, never mind the implications for historic convictions, but did you form a view that the Post Office could no longer reasonably maintain that the Horizon system was robust in the light of, in particular, the opinion at paragraph 35?
Okay, so I'm sorry, I've read that. Could I have the question again, please?
Did you form a view that the Post Office could not reasonably maintain that the Horizon system was robust or had been robust in the light of Mr. Clark's opinion, in particular that at paragraph 35?
No, I didn't.
Did you think that it was still open to the Post Office to say that, notwithstanding the advice it had received, it could say that Horizon was a robust system and the data that it produced had integrity?
I think to me, I don't think so, and I don't think so because it's conflating quite a lot, some isolated examples, admittedly in an extremely serious context. I totally acknowledge that. But I think in terms of the reliability and robustness of the system as a whole, you look at the operation of the system as a whole, which was what Post Office was doing, being used every day. And
there's so many thousand transactions, there's so
Exactly.
many million customers, a billion a year. That line.
essentially, yes. It's not a line, it was what was happening every day.
It was the line, though, wasn't it? That was the line to take, wasn't it?
I'm sorry, that has a pejorative connotation to
Absolutely.
what you're saying, and I don't believe it was, but it is a line that was used, yes.
Why were the concerns about Mr. Jenkins not taken to the police to investigate?
I don't know.
Was there any discussion of that?
I don't recall that.
Was there any discussion of which you were a party or of which you were aware that the police should be called in to investigate here?
I don't recall that.
Was there any investigation conducted by the Post Office of which you're aware into Mr. Jenkins and the matters that had been raised in Mr. Clark's advice?
I don't recall, no.
Were any instructions given as to how the information contained in Mr. Clark's advice was to be handled and disseminated?
I don't recall any discussions of that, no.
Was a decision made as to whether or not the information contained in the advice should be disclosed to past defendants, possible appellants, civil claimants against the Post Office?
At that time, this was arising at a time where Post Office's disclosure duties in prosecutions was being considered. I don't know to the extent to which the specific Jenkins witness evidence of this particular advice, I don't know to what extent that folded into it. So I think the answer is, I'm sorry, if you give me the question again, I think I can answer it.
I'll put it another way. Do you know why the information in Mr. Clark's advice concerning Mr. Jenkins was not disclosed until the criminal appeals in November 2020?
I don't know why it was. I don't know why it wasn't disclosed.
That can come down from the screen, thank you. Given that Mr. Clark's advice about Mr. Jenkins concerned the probity and integrity of one of the architects of the scheme, of the system, Mr. Jenkins himself, was consideration given to whether that had a wider implication on the reliability of the Horizon system itself?
No, I don't recall that, no.
Were the concerns about an employee of Fujitsu, to your knowledge, then discussed with Fujitsu?
No, I don't know.
What did you try to do to ensure that people in Fujitsu who needed to know this information got the information that one of their employees had, according to the Post Office, been given discreditable or tainted evidence in court?
That's really, can I check the privilege point on that, because we're dealing with...
No, just answer the question.
Okay.
If somebody wants to take a point on privilege,
I'm sorry,
they'll stand up.
Thank you. So could I have the question again, please?
What steps were taken, to your knowledge, to raise any concerns about this employee of Fujitsu with Fujitsu? I worked with Wimble Bond Dickinson to work out an approach that we could, the correspondence, a means by which we could raise the issue with Fujitsu, which we started off by, I think, looking at drafting a letter that would bring it to their attention. Mr. Williams, one conclusion that might be drawn from the fact that the Post Office, or part of it, acted as if the 3 bugs raised by Second Sight was revelatory, that no one investigated what knowledge the Post Office in fact had of the 3 bugs and when, and no one disclosed the Post Office's view that the expert that it had placed reliance on was discredited, was that the Post Office had now entered a cover-up mode. Is that true?
So again, there's quite a lot in these things that don't know. So I think you're asking me could somebody see that? I think somebody probably could see that.
Well, is it factually correct? Was a decision made, let's not find out when we in fact knew about all of these bugs. Let's, at least some of us, pretend this is revelatory.
That wasn't the impression I had.
Let's not disclose to convicted defendants that we have taken this view of an expert who has given evidence, or a witness who's given evidence either in writing or orally in court. Is that we're now entering a phase of seeking to cover up what's happened.
I think to do that requires a positive decision, and I'm not aware of that decision having been made or communicated to me, or I became aware of that in any way. I accept actions weren't taken, but whether that was, I wasn't aware of anything that said that was a deliberate choice.
So you're not aware of any sort of master plan, as it were, that said, let's not investigate when we in fact knew about this. Let's, to the outside world, suggest that Second Sight has uncovered something about which we didn't know. Let's not tell convicted defendants about the view we've taken of Mr. Jenkins' evidence. There was no meeting of that kind or instruction of that kind.
Not that I was aware of in any way.
Did you view...
Well, that I recall, anyway. I mean, I think I would remember something like that, but I don't recall that.
Did you view the issue raised by Mr. Clark's advice as relating solely to the Post Office's past criminal prosecutions?
Yes.
Accordingly, did you not consider the potential impact on past civil actions?
No, I didn't.
Did anyone do that?
I don't believe so.
as a lawyer with significant experience of civil litigation, at the centre of the team that was dealing with Horizon at the time, if anyone had considered the potential impact on civil proceedings, you would have been aware of it, wouldn't you?
I would say, oh yes, I would, sorry, thank you, yes.
What did you, in fact, do as a result of the receipt of the 15th of July Simon Clarke advice?
I think I read it.
And put it away?
I suspect, yes, it was being dealt with by what I considered to be what appeared to me, I should say, to be the people who were advising the business on the steps that should be taken. I'm not sure that what I saw in there necessarily impacted other activities in the business. He hadn't, I don't know, I wasn't aware of him giving evidence or any live proceedings at that time where the particular issues raised in here were germane.
Going back to the advice, please. Poll 3 zeros 4 zeros. And page 13, please.
Yes.
Under Mr. Clarke's conclusions, what does this all mean? In short, it means that, I'm going to replace the text where it's the correct name, Mr. Jenkins has not complied with his duties to the court, the prosecution or the defence. And then paragraph 38, the reasons why Mr. Jenkins failed to comply with his duty are beyond the scope of this review. So in 37, Mr. Clarke advised that Mr. Jenkins had not complied with his duties to the court, the prosecution or the defence, and 38 said the reasons why he failed to comply are beyond the scope of his, Mr. Clarke's, review, correct?
Yes.
Do you agree, therefore, that it left that question very much widely open?
I wouldn't have said very much widely open. I think if there was actions to be taken, I would have expected them to have been advised on next steps. What else is to be done?
Well, you would agree, I think, with this, that the reasons why Mr. Jenkins failed to comply with the duty was an important issue.
That certainly seemed to be what the criminal lawyers were saying.
It was an important issue that demanded answers.
I don't know what the issue, what the follow-on steps from it were, because that was for those with the expertise to advise on.
Was it not considered imperative to ascertain the circumstances in which Mr. Jenkins had given written and oral evidence in some Post Office prosecutions and, according to Mr. Clarke, had breached his duties to the court?
I really can't comment on matters of the criminal justice system. I just had no familiarity with it and what was required or not required.
Did you ask questions of Mr. Singh, or indeed any other of the lawyers in the department, or engaged in discussions with them as to whether Mr. Jenkins had been properly instructed as to his or an expert's duties of disclosure? I think I recall raising orally with Cartwright King. And what was the answer you got back?
Oh, I'm sorry?
What was the answer you got back?
I don't recall one.
Did you ever see any instructions which the Post Office had provided to Mr. Jenkins that might properly set out his duties to the court?
I haven't seen that, but also I didn't look for it.
When you read this advice, did it give rise to any concern in your mind that what you read might be indicative of any broader prosecutorial failings by the Post Office?
No, because I didn't know enough about the prosecutorial process to know where it may lead. It certainly seemed to be addressed seriously by those who understood the context in which it was relevant. So I don't know where else it would have gone beyond that, I'm afraid.
Were you aware of any discussion within Post Office Legal at this time as to whether the appropriate course might be actually to speak to Mr. Jenkins to understand events from his perspective?
I don't recall that, no.
So thank you. That's a convenient moment. It's just up to 3:10 now. Might we break until 3:25?
Yes, of course.
Thank you, sir. Good afternoon. Can you see and hear us?
Yes, I can, thank you.
Thank you very much. In the next set of questions, Mr. Williams, please don't worry about issues of privilege. They have been resolved between the inquiry and the Post Office.
My apologies for that.
No need to apologise. Can we look, please, at poll 00193383? Can you see at the foot of the page, there's an email from you to Leslie Sewell, Susan Crichton, Simon Baker and Hugh Flemington of the 11th of August 2013. And you say, Leslie, please find attached 2 drafts of a letter to put us on the record with Fujitsu about the issues raised in Second Sight's interim report and the impact of them on court proceedings we bring. The drafts differ in tone. The, quote, shot across the bows aims to put pressure on Fujitsu to work with us to improve Horizon and user confidence in it. The letter of claim goes further, tying the issues to our contract with Fujitsu and escalating them through its dispute resolution procedure. In either case, we need to set out what we want Fujitsu to do. That should set the tone for the letter. The more aggressive we are, the more defensive and therefore less supportive Fujitsu are likely to be. Can you tell me which approach to take? Can we look, please, at poll 00140620? Can you see...
Could I get a reference, bundle reference?
Yeah, E77.
B?
E77.
Yes, thank you. I have it, thank you.
This is headed up letter of claim, and it appears to be one of the 2 attachments to your email, albeit I'm not clear whether it's the shot across the bows letter or the formal letter of claim letter. I don't think that matters for present purposes because it's the content that I wanted to discuss with you. Can you see it's a draft letter to Fujitsu and says it's a letter of claim pursuant to the practice direction? In the background, it says Post Office has commissioned an independent inquiry into Horizon, which is being conducted by Second Sight. The report was published on the 8th of July. Although the report found no evidence of system-wide problems with Horizon, a number of criticisms were levied against the system, and further investigations are ongoing. In particular, Second Sight highlighted the following areas of concern, and can you see that 6 are then set out? Yes?
Yes.
Along with a note saying this list is taken from Second Sight's report. The Post Office needs to carefully consider whether responsibility for these criticisms falls on Fujitsu or the Post Office. And then over the page, it's noted the above criticisms are a product of only an interim review. We know there are a number of other potential allegations. Further details of these issues will be presented once received from Second Sight. One major area of concern is the scope and quality of Fujitsu's support to Post Office and court proceedings. Where appropriate, Post Office commences criminal prosecutions against sub-postmasters believed to have acted criminally, also brings civil proceedings. Data from Horizon is integral to the success of these court actions. It's imperative that this data is and is seen to be reliable. Perceptions of weakness in the system or any suggestion that Post Office or Fujitsu is attempting to hide weaknesses seriously undermines our credibility and significantly increases the complexity and the cost of court proceedings. And this is the paragraph I wanted to ask you about. The Post Office was therefore disappointed to discover that witness evidence prepared by Fujitsu may not have been fully disclosing historic, albeit known and resolved defects. This has led Post Office having to review all its historic criminal prosecutions for the last 3 years since the rollout of Horizon Online to ensure that it has not breached its duties of disclosure under the criminal court rules. Was your reference to the witness evidence prepared by Fujitsu a reference to the witness evidence of Mr. Jenkins?
I think it must have been, yes.
Was it the case that the Post Office discovered by the second sight report that he, Mr. Jenkins, may not have been fully disclosing historic defects?
So the question again, you said from the second sight report.
Was it the case that the Post Office only discovered from the second sight report that witness evidence prepared by Mr. Jenkins may not have fully disclosed defects in Horizon?
That seemed to me to be the case.
What investigation had taken place by the time of you drafting this letter in August 2013 to be able to say that it was only the second sight report that had caused the Post Office to discover those facts?
I'm not sure. I'm sorry. I think the question is what investigations. I don't think any investigations were undertaken. So I think it must have been that was the perception, the feeling. Although I have to say this is also a draft, so we may have invited comment on it before progressing.
And it's about that perception and feeling that I want to ask you. Remember before the break, I asked you questions about pretending that it was only upon the publication of the second sight report that the Post Office discovered facts that Mr. Jenkins may not have been fully disclosing historic defects in Horizon. This is an example of that, isn't it?
Of the perception that it was, yes, it would be, yes.
That it was a new discovery.
Yes.
A new fact.
Yes.
And I'll ask you again, what had been undertaken within the Post Office to discover whether that was true or not, that this was the discovery of a new fact, as opposed to something that the Post Office had in fact known about all along, the existence of the 3 bugs?
We didn't do anything, I don't think.
Can we turn, that can come down, thank you. Can we turn please to poll 0015 5555. This is a manuscript note dated the 2nd of September 2013. The authorship is not shown on the document, but do you recognise the writing?
It's mine.
You wrote this?
I think so. It looks like mine, yes.
And it appears to have been written by somebody, i.e. you, who had read Simon Clarke's advice of the 15th of July 2013. It refers to conversations with Martin Smith of Cartwright King and Brian Altman, KC. Can you see, if we pan out a little bit, please?
So, can I have the reference?
Yes.
Please. Just
Thank you. E96.
Thank you.
Are you at E96?
Yes, I'm sorry, I am. I've just been reading it. I'm sorry.
Thank you. Could you translate what the first part says, please?
It appears to be draft BPs.
Yes.
So the first piece is horizon-FJ positioning. Then it appears to be draft BPs.
So if we can expand that first bit, please. Draft, is that bullet points?
It might be. That seems sensible, but I don't know. So.
Okay. And then carry on translating, please.
Reports didn't contain all they should have. Reluctance to deal with known issues. As a which would be consequence. Do you want to verbatim
keep
for
going.
so NECS, which would be necessary to review cases to determine whether or not a partic deft, which I think
Particular defendant.
correct, was prejudiced by absence of info.
And then scroll down, please. You look at the next bit, copies of advice. Can we blow that up, please? Just under the part we were looking at.
I can probably do that from here. Copies of advice.
Yeah.
Arrow. Share under common interest privilege.
Can you help us? To whom was the advice to be shared under a common interest privilege?
I anticipate that would have been with Fujitsu.
Did that happen?
I don't believe so.
Do you know why it didn't happen?
No.
And then carrying on, please, the 6 statements.
6 statements as examples, might, underlined, be, quote, tech correct, to be technically correct, I imagine, but no in substance.
So 6 statements as examples might be technically correct, but not in substance.
Yeah, I think they might be missing a T. I think
Yes,
right.
and you've written that against paragraph 34 of the advice.
That does look right. Yeah.
And then underneath, please.
It goes to fairness / I think that might be obligations to do justice.
Thank you. And then next, telephone to MS.
Yeah, that's right. Ent report revealed existence of bugs.
Yes, and then underneath, does that say clashed with Gareth?
I think it does, yeah.
And then to the right-hand side of the squiggle.
And I've got without this, that'd be would have, so would have, continued with premise, all is okay, brackets, as per GJ.
What does that mean? What are you saying in this note here? Are you referring firstly to a telephone conversation with Martin Smith
Yes.
of Cartwright King?
Yeah, I'm going without this. I think that may be, I fear I might be speculating a little bit because it's been a long time, but would have continued, presumably with prosecution activities, with premise that all is okay.
As per Gareth Jenkins.
As per Gareth Jenkins.
So translating that, do you think that possibly means without the second sight report, we would have continued to prosecute on the premise that all is okay, as Gareth Jenkins said it was?
I think that's right, yes.
Thank you. And then the box over to second sight report.
I've got SS report equals, he tells of bugs not mentioned in his statements.
Yes, and then on the right-hand side? His statements say
we have lists to check, but doesn't say what types, what happens as a outcome.
Okay, and then scrolling down, please. You asked the question, what else?
Yep.
Is that a note to yourself?
I don't know. It's certainly it's my note, so I don't quite know what that's referring to.
Do you think it means?
There might be other bugs. I think that's as I'm
yes. If it's been discovered that Mr. Jenkins has said to second sight, i.e., he tells of bugs. Mr. Jenkins said things to second sight about bugs that were not mentioned in his statement. What else is there to discover about what Mr. Jenkins has not said?
I mean, that might be correct. I don't recall what I was putting that to, but...
Okay, we do have an issue.
With
I think it's
how,
the next line.
yeah, we do have an issue with how we share the info.
What was the issue? And sharing with whom?
I don't know what that's relating to.
You remember I asked you earlier about whether the Post Office had considered whether it needed to disclose the information in Mr. Clark's advice about a view that essentially Mr. Jenkins was a tainted witness, he had breached his duties to the court, needed to be shared with convicted defendants. Do you think that was part of your discussion with Mr. Smith?
That's plausible, but I don't know.
Why were you discussing these things with Mr. Smith if your expertise was not in criminal law?
I don't know. I may have been just the one who was asked to see what we did. But I'm certainly speaking to Martin Smith, who does have the expertise. Oh, I'm sorry. I do know why. I beg your pardon. Sorry, it's come back to me. One of the outcomes of the second site report was dealing with Fujitsu, and I was asked to sort of help with that. That was sort of on my agenda.
Underneath Martin Smith, and I think that says inference.
Yes.
Can you tell us what bullet point 1 is?
I think that's system designed to look for bugs, but doesn't mention any. By implication, there are none, because none are mentioned.
And then to the right-hand side, dealing with this page as we go down, you've written, so we know of some of these, and then what were we doing to instruct Gareth Jenkins? You remember I asked you before the break whether the question of what the Post Office had done to discover the instructions that it had given to Gareth Jenkins were, and you said you don't think consideration was given to that, or you couldn't recall any consideration.
No.
It appears that such consideration was given by you.
Oh yeah, well I thought I did say that I'd raised it with Martin Smith. I thought I did say that in my answer. Didn't I? I thought I did. I beg your pardon.
What was the product of your discussion with Martin Smith then as to the issue of what the Post Office had done properly to instruct Gareth Jenkins?
I don't know from this. I don't think any actions were taken.
I mean, was there any introspection at all here by the Post Office? To what extent do we, as Post Office, bear a responsibility for what has been revealed by Mr. Clark's 15th of July advice?
Oh yes, I would think so. And on that, we'd have been asking those who advise on the appropriate, who raised the issue, on the appropriate steps to take next.
Was anything specifically done to answer the question that you raised there? What were we doing to instruct Gareth Jenkins?
So the question again?
Was anything done?
I'm still familiarising myself with the document, I'm afraid, sorry.
But what was done to take that issue forwards, to your knowledge? Discovering what the Post Office had done properly to instruct Gareth Jenkins?
I don't know that anything was done.
Was there any sense that you're aware of, let's best not answer that question, because we might not like the answer?
Not that I recall, but...
Carrying down on the left-hand side, please. M. Smith, first point, don't think
has ever been advised of his duties. There you go.
Who's the he?
Oh, there must be Mr. Jenkins, I think. Must be Mr. Jenkins. Sorry, my voice dropped.
So your criminal law expert was telling you that he didn't think that Mr. Jenkins had ever been advised of his duties. What was done as a result of that?
Again, I don't know. I'd been looking to Martin Smith for the reaction to that.
But you're the company lawyer, aren't you? You're the post office lawyer, and your external lawyer is telling you, we don't think this expert who Simon Clark has written a very powerful advice about, with very concerning and difficult conclusions in, was ever advised by the post office or anyone of his duties. What did you do with that information?
What I do recall, various discussions I may have had with Martin over the time, that if there was action we needed to take.
So what action was taken?
Well, none, but it was saying if you tell us we need to do something, I genuinely think Post Office would have been doing it.
Well, did you say back, well, that's an important point, we after all are the prosecutors here. It's Post Office Limited on the charge sheet. We owe duties to the court. There needs to be some investigation here of what we, the Post Office, have done wrong, if anything. Can you look into that, please, Martin, rather than lumping it all on Mr. Jenkins?
Well, I don't know if we're doing that. This is a discussion on how to take something forward with Fujitsu, with the criminal lawyer, and I'd have expected through this, given I'm not a criminal lawyer, for the advice on what's appropriate or not to be taken to be coming in that, well, from the expert.
Underneath, does that say started with MISRA 2010?
Yes.
And then if you can read the final 3 bullet points on that page.
Has turned up since, but not given.
So does that mean, do you think in context, Mr. Jenkins had turned up to court since 2010, since MISRA, but hadn't given evidence, as in fact was the case?
That's my understanding. Yes, I think that's right.
His duty is to the court.
Yes.
And then what does the last bullet point say?
It seems to say, seem to rely on this. CK haven't done anything since.
Do you know what that means?
No. I'm sorry.
And then the final part on the right-hand side of the page, underneath the part that was double underlined, signed statements.
After telling SS of the bugs.
Does that mean that Mr. Jenkins, or you were being told that Mr. Jenkins had continued to sign witness statements that didn't make mention of bugs, even after telling second sight of the bugs?
I think so, yes.
We'll come to that later in this phase. Fujitsu will say, can you translate the rest, please?
It's up to defence counsel to raise the issue.
Do you know what that is? Is that Mr. Smith speaking there?
I don't know. I don't know who put that. It may have been me, it may have been him.
Can you help us with the context of that? I.e. Fujitsu will say it's up to defence counsel to raise the issue.
My guess is in terms of bringing us to the attention of Fujitsu, they'll say, well, you were conducting the prosecutions, you should have told him it's your fault.
And then the last part on that page, in the bottom right.
I think it's wholly affected, hyphen, I think they might say it's cute. And then it's RFJ legal reviewing this.
Are Fujitsu legal reviewing this? Yeah. Yes.
And then it's a quote, and correctly account for it misleading.
Can you help us with what that note means?
No, I'm sorry. I mean, I don't know what this is. I'm
What one of their employees might have breached their duties to the court, presumably.
I don't know. I'm sorry. I don't know what that is.
Okay, over the page, please, to page 3. Is this a continuation of the same note?
Quite possibly, yes.
Can you help us with what the first part means?
It says Fujitsu, this is how we did it, and confirm.
Yes.
Plus, we don't do bug-free. It's up to you what you do with the system. Plus, per CK, defense counsel should raise this.
Is this Mr. Smith telling you what he thinks Fujitsu might say, you recording what you think Fujitsu might say, or something else?
I don't know now, I'm sorry.
And then I think the rest is either irrelevant or ascertainable and irrelevant. Do you think by this time the Post Office had realised that it had failed to instruct Mr. Jenkins properly as an expert witness?
Oh, yeah, yes, I'm a Post Office employee, so yes.
If the Post Office had failed to instruct Mr. Jenkins properly as an expert witness, in accordance with the Post Office's own legal duties, would you agree that that was a serious issue?
If we'd been advised it was, yes.
Would you not regard it as serious of itself without having to be told?
In this context, I mean, we knew it was serious because it had been raised, but what to do with it? Again, I'm sorry, could I have the question again?
If it was the case that, as this note may indicate, it can come down incidentally, that the Post Office, through you, realised that, or had been advised, that the Post Office had failed to instruct Mr. Jenkins properly as an expert witness in breach of its own legal duties, then that was serious.
Well, I didn't know what Post Office's duties were, which is, as a prosecutor, which was I was speaking to the criminal lawyers.
We've seen a note which says we don't think he has ever been advised of his duties. Did you think that was serious?
Well, I don't know. I'm not sure in the civil context when we. Oh no, we do with experts. You're right. So yes, I do think it's serious.
Why were you having this conversation with Mr. Smith?
Well, because we wanted to raise it with. We thought it needed to be raised with Fujitsu. That was the. What are we going to raise with Fujitsu?
And the type of issues that we see discussed here,
yeah.
Namely, a record of a witness continuing to sign witness statements that fail to mention bugs, even though he's told Second Sight about them. A record of the breach by the witness of his duties to the court, a realisation that he, it is said, has not been advised of his duties to the court. Were they, to your knowledge, ever raised with the Post Office Board?
I don't know with the board. I think they were put in. There are other drafts of letters to Fujitsu, I think.
Yes, I'm talking. We can see what was said in that draft letter.
There were others, I think.
I'm asking where else that information was directed. Was it sent up to the board, to your knowledge?
No, not to my knowledge, no.
Was Second Sight told about it?
No, not to my knowledge.
Was the mediation scheme working group told about it, to your knowledge?
I don't know whether they were or weren't.
Was Mr. Altman at KC told about it?
Of the issue with Gareth Jenkins?
No, I'm taking it beyond the issue with Gareth Jenkins.
Right.
I'm talking about a realisation that the Post Office itself may have failed to instruct Mr. Jenkins properly as to his duties?
Quite possibly not. Put it this way, I don't recall him being told that, no.
Was it, to your knowledge, raised with the CCRC?
No, not unless it sort of came out from the advice notes we'd had, no.
To your knowledge, was the first time that the Post Office acknowledged to any external body that Mr. Jenkins had not been properly instructed as an expert until this inquiry?
Quite possibly, yes. Oh, it may, I don't know, it may have come out in the Court of Appeal proceedings.
I don't think there was any, from memory, direct acknowledgement in the Court of Appeal proceedings by the Post Office that that was so.
I'm sorry, I'm speculating there, I beg your pardon.
Can we turn, please, to poll 00125758? I'll give you the tab number in a moment. 00125758. B176, Mr. Williams.
176.
Yeah, B176. Have you got that?
Oh, I'm sorry, I beg your pardon. Yes, I have. Sorry.
You'll see this is a speaking note for a meeting with the CCRC on the 8th of May 2015.
Yes.
You can see who the attendees were intended to be. From Post Office side, you and the General Counsel, Ms. MacLeod. Did you write this speaking note?
I think I may well have done.
Yes. And if we just scroll through it, please. You propose to set out the background to the complaint review and mediation scheme. Post Office is a retailer. It's the UK's largest branch network, 11,500 branches, 8,000 agents. Postmasters handle Post Office money, £70 billion in cash. There's a duty to account under contract and common law, under agency, for daily cash declarations, weekly balances, and monthly trading rollover periods. Post Office monitors branch accounts. There's an audit if questions about declared levels of cash holding. If audit reveals a shortfall, then the Post Office seeks to recover under a contractual right that shortfall, and you quote in clause 12 of the contract, suspend, termination, potential prosecution if conduct is suspected, prosecutions under the POA, about 50 a year. Over the page, please. Post Office uses the Horizon accounting system in every branch. It's supplied by Fujitsu. First introduced in 1995, online in 2010, 60,000 users or more, processing 6 million transactions a day, 2 billion transactions a year, 500,000 users since launch. The key principles of it, 2.3, some postmasters started attributing branch losses to Horizon. Early 2012, James Arbuthnot asks the Post Office to look into it. From your knowledge and understanding, was that the first time that the attribution of branch losses was raised in early 2012?
I think I don't know when PMs started attributing branch losses.
And you knew, I think, about the Castleton case
Yes.
So he had been doing it making that suggestion in the early 2000s.
Correct, yes.
And you knew about the Seema Misra case, and he had been making that suggestion in 2009 and 2010.
Correct.
And did you know about the Computer Weekly article that summarised half a dozen or so sub-postmasters who said exactly the same thing?
I'm aware of that article now. I don't quite know when, but it was likely by this time that...
By mid-2015, you would have been aware of the Computer Weekly?
Yes, absolutely.
Okay, so is it right that then this is not supposed to be a comprehensive account of when problems with Horizon first arose?
No, I think what I've done here is PMs at some point started attributing losses, but then in early 2012, that's when Lord Arbuthnot
okay.
forward. So I'm not seeking to say it started in 2012. I think it's a
okay.
point.
In 2012, Post Office instructs Second Sight to look at some of the cases. The first report was in July 13, and you cite the no evidence of system-wide systemic problems with Horizon software, but issues with the way we dealt with individual postmasters. Post Office was very concerned about the impact on criminal cases. It considered the July 13 report against the prosecutor's duty of continuing disclosure, set up a SIFT review process. Suitability was checked by Brian Altman, made disclosures as a consequence, revisited its approach to agent engagement. And then 2.5, scheme to resolve individual complaints. You'll read what's summarised there. And then over the page. 2.6, focus of complaints continue to be processes and practices. The Second Sight investigations, you told the CRC, have shown that the majority of branch losses were caused by errors made at the counter. Second Sight expressly accepts it's not an expert in criminal law and procedure, but still, in Part 2, state the Post Office might not have investigated claims properly, have the evidential foundation to bring a criminal charge. These statements have entered the public domain and may encourage people to take action. Other avenues being pursued. And then categories of responsive documents under Section 17 notices, if you just scroll to the end. You enter into a practical discussion about provision of material. Yes? Why is there no mention there of what the Post Office have found out about Mr. Jenkins?
I think by this stage we had disclosed, we may have disclosed the Brian Altman advice reviewing the past. What I understood the impact of the Jenkins the Jenkins issue was that it triggered Post Office's duty to make further disclosure, or to consider further disclosure in case
of the Second Sight report,
of the Second Sight of the materials that we'd been advised to disclose, which I think was in some cases the Second Sight report, in some cases, in most cases I thought it was both, the Helen Rose report. That process had been reviewed by Brian Altman, and the advice on that had, I think, although I'd like to check the dates, been shared with the CCRC by the 8th of May 2015. If it hadn't been, it was around the time of this. It was disclosed.
And the Simon Clark advice
of
the 15th of July 2013?
I don't think the Cartwright King advices were shared.
And why was that?
We tended to respond to requests for information from the CCRC, and it was the Cartwright King advice was referred to in Brian's advice, and we invited the CCRC to tell us which documents they would like from it, and some of those were, I believe, provided, but not those. I think that's what it's.
How would the CCRC know about the Clark advice?
It would have been referenced, I think. I hope. They would only know, I think, if it's properly referred to in Brian's advice.
Mr. Altman's advice.
Would you like me to check to see whether that?
No, it's okay. We can
that was done. I don't want to mislead. That's my recollection, but I'd like to check it.
Why wasn't it something volunteered?
I don't know. It's some things were volunteered, I think, but it wasn't a routine.
Yeah, I'm asking about this one.
No particular reason. The material they asked for was provided. It indicated what else there might be. And so, I don't know at this time, but certainly the process we had going forward with them was not to show them what we thought they might be interested in, but for them to conduct for them to conduct their investigation and follow the lines of inquiry that they would want to. That was the repeated advice I recall us receiving, is the CCRC would conduct their own investigations and should be left to it.
Can we look, please, at poll 0010 3238? I'll just wait for Mr. Stevens to turn that up. Poll 0010 3238. B182, please.
B182, thank you. Yep.
And can we turn to page 2, please? And scroll down. We can see an email here of the 1st of August 2016, and if we scroll on, please. If we keep going. We can see that it's sent by Amanda Pierce, the group leader of the CCRC. And if we go back to the beginning of the email, please. She says, hi, Rodric. And then under documents, I'm afraid I've also got some further requests for information and documents. Under documents, we met with Ron Warmington of Second Sight. He mentioned a couple of documents we think it'd be helpful to see. The thematic spreadsheet, which Second Sight created, identifying the alleged faults and problems. A June 14 report, which Mr. Warmington prepared on Post Office Investigations Department and process. I attach a Section 17 notice to cover the request. We're trying to locate the transaction logs for the Misra case. We haven't been able to find them in the data room. We have found a 255-page event log and a 29-page log of transactions, but no sign of the full transaction logs. If the logs weren't printed out at trial, are you still able to access them? I haven't sent a Section 17 notice. And then scroll down. In November 15, Post Office reported an issue whereby payments had been duplicated on Horizon. It was reported that this was caused by the user forcing log-off. We've also seen this referred to as the Dow-Mellington error. Would it be possible for the Post Office to provide us with an explanation of this issue? 2, we've seen a number of references to the receipts and payments mismatch problem, which we think has also been referred to as calendar square, Falkirk problem. Are we right in thinking they're the same thing? Could the issue affect transfers between stock units within a branch? 3, we've seen references to some sort of fault log produced by Horizon. I understand that this has been variously referred to as the peak incident report, Pinnacle, and the known error log. Do these refer to the same thing? Is it one document or is it a series of documents? I'm trying to get a better sense of what they are. Agree, all very relevant, direct and penetrating questions.
Yes.
Can we scroll up, please? To page 2. And keep going. And keep going, please. To the top of page 2. There, that's it, thank you. You send this on. We just look at the bottom of page 1. That's from you. You send that email on to Andrew Parsons and others and say, can we discuss it? I'd like to start thinking about whether and how we can start forcing the issue with the CCRC. They've been looking at these for a long time and seem to be jumping down every rabbit hole they're directed to. Why did you think the CCRC was jumping down rabbit holes?
For two reasons, I think. Now, the Computer Weekly issue was I think it referred to an outreach bug, which I think when we discussed it in turn, I don't know where it came from, seemed to have been a recent event. I'm not sure whether that actually is the case or not, but that's what I recall being at the time. But I think more pressingly, they'd asked for quite a bit of disclosure on an employment tribunal claim that was, as far as I was seeing, it was an employment tribunal matter, it was unrelated to any prosecution material. And it just, what I think was going on there was what my impression of what we were seeing was lots of people raising lots of issues that would get looked into and not go anywhere, and just extend the period of review without reaching conclusions.
You just agreed with me a couple of minutes ago that the questions that the CCRC were raising with you were relevant, direct and penetrating issues. Why did you think they were going down rabbit holes?
What I think what I've just said, for example, the Computer Weekly. I think I'll be frank, I think that's just me writing a short email. I think what I was trying to actually do is what Post Office's approach to the CCRC had been was to, as I said before, leave them, and that was the consistent advice, leave them to their investigations. They knew what they were doing and how they would go about it. I think around this time, because the group litigation had started, I think it started, in April 2016, there was some discussion around, well, how long does this take? That's a question I was frequently asked. And I thought it important to at least think about testing what had been our position and to see whether it was still viable and valid. You know, is how we've been dealing with this appropriate? Should we be thinking about doing something else? And that's what I was trying to do there. Is this an ever-expanding, running down the rabbit hole, as I seem to have intimated there, or should we stick to what we have been doing and what I believe we continue to do, which is to engage with them as they required from us?
It's that siege mentality again, isn't it, Mr. Williams? Challenges to the Post Office are hostile and must be fended off rather than considered on their merits.
I think that's maybe overstating it, but there's probably something in that. I think that's fair.
You say that they're being directed to rabbit holes. Were you paranoid that others were acting in concert with the CCRC? I said seemed to be. I didn't know whether these were things they got to on their own or at prompting. But I'll be frank, I'm quite sure they would have been doing what they do with us, which is their own investigation impartially. Did you think they were lacking impartiality?
No, not in any way.
Why did you want to force the issue with the CCRC?
I wanted to start thinking about whether we can. As I say, to me, this is testing. Is our approach still the right one? And it turns out, I believe, as our subsequent actions, it was the right one, to continue to leave them to do the job as best they knew.
Well, is there really an option there? On the one hand, we should leave the statutory body that investigates possible unsafe convictions and miscarriages of justice to get on with its work, or we stand in their way.
I don't think so, but I was often asked, I seem to recall being asked, when are they getting back, what can we do? And it helped me to be able to say, look, this is the approach we've been taking, we're keeping it under review, we test it, and it is still the right thing to do. Even if it seems, as you've just laid out, frankly, obvious. I think it's important to keep things under review.
Can we look at a different aspect of this, please, and turn to paragraph 76 of your witness statement? That can come down there. Which is on page 38.
Oh, sorry, yes.
I think that must be a rogue reference. I'll move on. Poll treble 06, 6789, which is tab B64. This is an email chain between you and Mr. Smith regarding disclosure of the Helen Rose report. You remember what the Helen Rose report was?
Yes.
Can you, for those less familiar, summarise your present understanding of what the Helen Rose report was?
I think Helen Rose report, it's unfortunate we tried for a while to have it referred to as the Lepton report, as it concerned a branch rather than an individual, was an issue raised by a member, I think, of Post Office's security team in connection with an issue raised by Second Sight through a spot review, ultimately through a spot review on, I actually can't remember what the technical piece is, but reversals, I think, are visible from information derived from Horizon.
Thank you.
Question about whether the reversal was generated by the system or by a user.
Can we turn, please, to page 4 of this chain? At the foot of the page, in the context of the case against Mr. Ishak in July 2013, Martin Smith sending a copy of a letter to Mr. Flemington and copied to you to be sent to Mr. Ishak's solicitors. And then up the page, please. Keep going. We can see your reply on the 10th of July 2013. Thanks, Martin. First point, we presume that Helen Rose's report is being disclosed because the Post Office's evidence in the prosecution included an ARQ report. Is that right? Second report, Helen Rose's report is marked confidential and legally privileged. I understand she did this because she prepared the report to give to Post Office Legal for advice, for legal advice on the implications of her investigation. Please call on her number to confirm. Please therefore consider what information from the report needs to be disclosed to Mr. Ishak's solicitors and in what format, i.e. whether parts of the report should be removed or redacted, e.g. the recommendation section or the non-privileged material, e.g. the background transaction data repackaged for disclosure to the defence. If you advise that Helen's report does not attract any privilege, please ensure the reference to privilege is removed from the header. I don't want someone else to say the report is privileged but we thereby we waive thereby giving rise to possible difficult issues of collateral waiver. So you were asking Mr. Smith why the report was being disclosed first, yes?
Yes.
And you were asking for advice on its privileged status. On what basis did you consider the report to be privileged?
Well, I wasn't sure whether it was privileged or not, which is why I was asking the question. But I had understood when this came up that the report, as in the physical report, had been prepared for the purposes of obtaining legal advice. As in, here's an issue, what do we do?
And so what did you think that occasion of privilege was? To obtain legal advice about what?
Whether it raised issues that needed to be disclosed.
No, why did you think it was possibly the case that the Helen Rose report enjoyed privilege?
It's the same, because I thought it had been prepared to give to the Post Office Legal for advice. We found this issue. What are the legal implications, Post Office Legal? That's what whether that actually was the case or not, I don't know, which is why I was asking Martin Smith what his view on it was. And it was marked privilege, which I know isn't determinative of anything, but somebody thought it was privileged, and I wanted to know, and not having any familiarity with the criminal justice system.
In any event,
I wanted the expert to tell us what to do.
if we move up, please, to page 1. At the foot of the page. Mr. Smith says Rodric, and then there's an explanation of privilege. And second sentence, I guess here you suggest that such privilege attaches by reason of the Post Office's contemplation of adversarial proceedings involving Fujitsu. Is that right? You thought that Helen Rose's report was... No. That's just way off beam.
It was.
In criminal litigation, the emphasis is on ensuring a defendant is not prejudiced by the absence of material which would otherwise assist him or undermine the case against him. Criminal disclosure law trumps civil privilege, but only in circumstances where the material in question meets the test for disclosure. Quite a lot in there. Thus, there are only a limited number of ways in which we can prevent disclosure of material which we would otherwise be required to disclose to defendants. Then over the page. Seek a public immunity, I think that's meant to mean public interest immunity, certificate from the trial judge, as we did in another case. To achieve this, we would need to demonstrate a real public interest in non-disclosure or terminate the prosecution. And then he sets out why Helen Rose's report is disclosable. And if we go to page 3, second paragraph, I'm in no doubt that this document is disclosable. If the matter were to come before a criminal court, the judge would without hesitation order the disclosure in an appropriate case. Then I think you gave your instructions on page 1. Please disclose all information from the report that needs to be disclosed. Do so in a form of a new standalone document. Helen presented the info in the form she did as to provide it to the legal department for its view. Why did you want a new standalone document?
I think it just separated I think I said it earlier, it just removed any question about what had been prepared for. I had been told, I think, by Cartwright King that you can give disclosure in the form of disclosure notes as opposed to the document itself. And I had thought, look, they know what needs to be disclosed from there, which is the key of it. You disclose what needs to be disclosed. do it in a way that sort of removes the question around this.
Would that not have had the effect of obscuring the context in which the report had been originally generated?
Not necessarily. It could have been as simple as removing the privilege piece, which I think is what happened. I think I saw a version of it at some point where it effectively went without the markings. But certainly that wasn't.
And then lastly on this topic, before the break, can we look at poll 0010-8163, please?
Yes.
An email from you to Martin Edwards. Can you help us with who he was?
He was at this time, I think, the Chief Executive's Chief of Staff.
Within Post Office?
Within Post Office, I beg your pardon.
And if we scroll down to point 3, the briefing can address the issues we discussed yesterday, namely whether the Helen Rose report's in the public domain. No, it's not. And then I think it's sensible to keep references to the Helen Rose report to a minimum. In what context were you advising the Chief of Staff to keep any references to the Helen Rose report to a minimum?
I think in this you need to get this is a document where the full trail, I think, is important and the context of what's happening. I think I'd been asked, if you go to the big, can I have the tab reference?
We'll give you the tab number 84, B84.
Oh, sorry, that's 184. So, so if you go all the way to the first...
Pages 4 and 5.
Yes, thank you.
If we look at the foot of page 4 and onto page 5, Mr. Edwards sends you some text for a report to the CEO on criminal cases.
Yes.
And the text is our criminal barrister, Brian Altman QC, has completed his review of the approach we're taking to reviewing cases that have been subject to prosecution, in particular at looking whether we're complying with our duty to disclose the findings of the second site report of the defence teams. His conclusion is that our approach is fundamentally sound, providing us with strong grounds to resist any formal review of our prosecutions, for example, by the CCRC. To date, following several sifts of our external firm solicitors, I identified 11 cases where disclosure is required. It's a matter for the defence to determine what action they might take. And then scroll up.
So to put that in context, that to the best of my recollection is that I think that's in the, it's in the heading, it's a CEO report. So a report was prepared for the Chief Executive. I don't know to whom, I assume it's the board. It would be collected from various parts of the business on matters that had been, were of interest to the board. I don't know what the criteria for that were, and then they would ask whoever was around to give either approval, sign off the writing. So I don't know where the draft started from on that, but he was saying here's an extract for the CEO report, which as you can see is sort of relatively small, so very high level. What do you think? That's what I was asked to do. So I then, in the next one, I made some suggested amendments.
In the amended text we're looking at on the screen,
yes,
you added in the words that are emboldened and underlined.
Yep. That's right. I think, did I strike any out? Well, it doesn't look like. Well, I think I replaced some words where it felt like we might be overreaching.
And then if we go to page 3, please.
It's at that point, my understanding was the documents being considered through the SIFT review for disclosure and past prosecutions was not just the second site report, but also the Helen Rose report. And so I introduced it in at this point saying, well, hang on, it's not just that document, there are two of them.
Mr. Edwards asks you at the foot of page 3, is the Helen Rose report a key part of the disclosure? If so, I think we'll need to include the reference to it in square brackets below. So is that him adding the text in that we've just looked at?
Sorry, who's that? So I'm sorry, what am I looking for in the highlighted section?
Mr. Edwards replied, is the Helen Rose report a key part of the disclosure? If so, I think we'll need to include the reference to it in square brackets below. So it looks like he's added those words in, and Helen Rose, in the text on page 4.
The text on page 4 now.
Yeah. I don't want to spend too long on this.
Oh, yeah, no, I'm sorry.
About the intricacies of drafting.
Yeah, I beg your pardon. No, I think I'd added it. It's not in the...
My only question was on page 1 of the email,
I beg your pardon.
why did you want to keep references to the Helen Rose report to a minimum?
Or because I say this later on, it generated a lot of activity about what it was and what it involved.
Why did it generate activity about what it was and what it involved?
Well, we can see here Martin says, thanks. Unfortunately, I think I probably do need to give Paula more information on this. This is on page 2, as it's going to raise all sorts of questions from her and the board. Please, could you send me the report and any associated advice?
Yes.
So then I go, can we take some time to discuss?
Yes.
We agree. It's a quick... Martin says it's probably better not to mention the report specifically, as it will serve to confuse things.
Why would the mention of the report confuse things?
I don't know. I don't know.
And then we get to page 1.
Yep.
Where you say, I think it's sensible to keep references to the Helen Rose report to a minimum. And my question is, why did you think it's sensible to keep references to the Helen Rose report to a minimum?
So it was so the way I'd read this, it was a question about what's being disclosed. The Helen Rose report was something that was being disclosed, and then the briefing note we'd received, which I think must have been from Cartwright King, I attached a briefing note, says it's unlikely to require disclosure in any further cases. So in a short summary of matters, in a larger report on other things, as I understood it, it was something that didn't appear to be a live issue going forward.
Live issue for who?
For disclosure. And then, so it wasn't going to be something that was continuing to be disclosed. Actions weren't going to continue to be taken with respect to it, I think. And then I also added in that Brian's view was that it was added very little. So I'm sitting here thinking, I don't know if it doesn't seem to me to be particularly relevant going forward.
Thank you. Those are the only questions I asked today. So can we start at 9:45 a.m. tomorrow? And I'll pick up questioning with the shredding advice.
Yeah, and tomorrow, Mr. Beer, we embark on a newish form, well, not newish, a new form of procedure, do we not? In that the representatives of core participants will be given a 45-minute time slot, and I think 3 have claimed it, to ask questions of Mr. Williams.
That's right, sir.
And I'm just telling everyone now that in my view, this will only work if people are scrupulous about using the time, because the last thing we want is for the third person of the core participants tomorrow afternoon being truncated because the 2 before him or her have overrun. So it's 45 minutes each, and I propose to be ruthless about it, just for everybody to know. Mr. Williams, overnight, I dare say you'll want to relax if you can, but you won't want to talk to anybody about your evidence, I'm sure. And I know you understand that you shouldn't.
I do.
So much, and I'll see you all tomorrow.
Thanks, sir.
Thanks, sir.